My mother died.
What proof do you have that your mother died?
My mother did not die.
It's the only word that accurately describes the man, and we can demonstrate just that. Everybody thinks he's an asshole. Son of a bitch. Well, that's good, too.
Shut up! What the hell? Court's adjourned. In my chambers. Now.
Mr. Ponton, I believe you have a filter turned on in the video settings. You might want to take
we're trying to, can you hear me, Judge?
I can hear you. I think it's a filter.
It is, and I don't know how to remove it. I've got my assistant here. She's trying to, but I'm prepared to go forward with it. I'm here live. I'm not a cat.
I plead the fifth. I plead the fifth. I plead the fifth. I'm not going to get myself criminally in trouble. I plead the fifth. I plead the fifth.
Objection, hearsay. Oh my God, I don't advocate.
Steven called me a dumbass.
Yeah. Yeah. Hey. Huh. You hit go live, I hit high. Don't blend the mirror for the fly you saw. You built the stage, ring light, halo. Crime, villain, art, potato, can fatal. Overshared diaries, legal threats shaky. Sue the whole planet cause the comments got snaky. You call it harassment, I call it replay. You filmed the mess in 4K every day. I didn't script it, didn't cast, didn't scout. You tripped on your ego, now I'm trending off cloud. Substack, manifesto, spell check deceased. Paragraph long, but the logic real brief. Neighbors need restraining orders, court dates pending. But I'm the bad girl cause your rep is banding. The more you act up, the more you get sown. Strapped to my plow in the field you grown. Every cell phone clip is a row I reap. You farm your chaos, I just harvest cheap. This is America, freedom of speech. If the shoe don't fit, let it slide on your feet. You perform the circus, I just buy a seat. You feed the joke, I don't even gotta tweet. Lip filler, migration, face on vacation. Still got the nerve of defamation accusations. You stalk folks' lawns, but call me obsessed. Ma'am, you filmed it yourself, exhibit A, press yes. Court filing, hobby lawsuits on repeat. Paperwork warrior, but you're losing in the street. Crying bullying while you rage for views. Then monetize drama with tell-all interviews. You don't want laughs, cool, here's the hack. Log off, go heal, don't hit post on the crack. No stream, no meme, no thread to unpack. But you love the spiral, numbers say that. The more you act up, the more you get sown. Strapped to my plow in the field you grown. Every meltdown moment, Kerching, that's we. You plant the circus, I just thresh the beat. Free country, say what I please. You uploaded the clownery, don't sue me. You light the match, then scream at the flame. I just watch the smoke spell out your name. Yeah. Drop down, just live what I please. You up on in the pillory, ghosted, eager. You black, no lust, scream at the flame. Accountability, ghosted, ego on tour. Blame the audience, never the lure. If attention's a drug, you double the dose. Then shock Pikachu when the laughter post. So here's the deal, real simple math. No chaos crop, I ain't got a path. You stop the show, silence no cow. But till then, welcome to the plow. Faster! Don't slow down now, boo. I'm so proud of you. Faster! Don't slow down now, boo. I'm so proud of you. Faster! Don't slow down now, boo. I'm so proud of you. Faster! Don't slow down now, boo. I'm so proud of you. Faster!
Hey, welcome back. It is Wednesday. We are live, and I've been gone for a while. To your sister, darling. No. That goes to your sister. Oh my goodness, these children cannot follow instructions. I swear to you, Tug.
They love it when you get ready to live stream too.
I just said to him too, I'm going live. Do not interrupt me. And the instruction I gave him was go get ice for your sister. What does he do? He brings it to me.
That's
to me.
funny.
All right. I may need to step away a couple of times during the stream. Mr. Fox is still at work. He's working late. And that means that the children are up to their own devices and one of them is a cripple. So if I have to go and check on them, I'll have to do that, but it'll be okay. I'm sure you guys will understand. Now, we have all kinds of things to talk about tonight. We have a 45-page recommendation by Judge Bolitho. in the Fed 2 case, where I know all of you have heard about this. You're reading it, you're talking about it, you're discussing it. It's a whole big thing. One thing I don't want any of you to do, though, is to freak out about it, because things happen in court. Sometimes things don't go your way. Some things don't, Tug and I talked about this ever since Fed 2 came out, which was tortious interference claims are very hard to win. I don't think I know of one that ever has.
No, actually, the first thing I ever covered, Vic Mignogna. Vic Mignogna had so much loaded on his side. He was a dub voice actor. So if anybody's ever watched like an anime, a Japanese cartoon, the guys who English dub it, he was very well known, probably the biggest one. He gets accused of horrendous things, but these things are at least a decade to 16 years beyond. You imagine how insane that is, because you can't defend yourself against that kind of claim. Well, every convention save one drops him. They have evidence that people have been calling behind the scenes, sabotaging him. He didn't make it past anti-slap.
Wow. Yeah, and I remember that case. I remember reading or listening to a lot about it. There was tons of evidence that they had deliberately, maliciously interfered with his business, and it just didn't matter. It just did not matter. So it doesn't mean that Jeremy Hales doesn't have evidence that these people tried to interfere maliciously with his business. It's not what it means. I have read through it. We're going to read it tonight. I have read through it, and what I'm understanding out of it is that the judge is claiming there's a procedural issue, and he doesn't like the way that it was pled. And what that actually means is basically he wanted less making the allegation, more of how did that thing harm you specifically? So he's basically saying it's not enough to say Bruce Matskin sent emails to YouTube attempting to have his channel shut down, without then also including, and on this date, YouTube took this retaliatory action based on his email. And I think that's what he is saying. I mean, again, I'm not a lawyer. I do not know the Lanham Act. I don't know a lot about some of the things that that's in this complaint. So what we're going to do is we're going to read it. We're going to go through what it says. And then we're going to wait for whatever Randy is going to file next, because I'm sure it's not a done deal. The district judge has to sign off on it. But before the district judge does that, they have 14 days to appeal the recommendation. He has a couple different ways that he could go. He can actually, the recommendation is to dismiss almost all of the claims with prejudice, which I think is premature. After looking back on the second amended complaint, I don't think it was amended to cure any deficiencies. I think it was amended to add people, wasn't it?
I'd have to go back, man. It's been a minute.
Yeah, I think we need to go back and look at that, because if it wasn't amended to cure deficiencies, then plaintiffs could say we were not given a chance to cure deficiencies and we would like to do so. And so they can file a motion to amend to cure the deficiencies. But there's other ways they can do it too. They can ask for a de novo review of the entire case, which
that's what they're going to do. That's the way you go.
Probably.
Yeah.
Although I don't know, I might want to, if it were me, I might want to amend it to cure the deficiencies. I think those deficiencies can be cured. That's the thing. I think it can be cured. I think saying, well, there's no evidence that it was sent to Whatnot did anything. Excuse me? Yeah, there is. There are emails between Jeremy and Whatnot, and all of the interference. I believe he lost one of the contracts he had with them, and it was redone to something else. There was all kinds of professional stuff going on between him and Whatnot, and Bruce emailing Whatnot. I mean, all of that was there, and he has that evidence. Now, was it sufficiently pled in the complaint? I don't know. But the judge is saying he doesn't think so.
Yeah, I don't know the Lanham Act. That's a very novel approach, so that is a problem for my knowledge of a case. It's the first time I've seen that thrown in. So
right, me too. Me
You know,
too.
the wild thing
Much
about
to
this
say
stuff
about it.
is, well, the wild thing is, you know, of course the ecosystem wants to, you know, take their victory lap, which, hey, if it falls, it does fall, and okay. But the problem is Bruce is in trouble. Bruce is already in trouble with other stuff. He went too far. He ended up with his unlicensed practice of law. That's a big problem for him. And Lisa, holy crap. I mean, the thing, I was saying this last night, Fed 2, best case scenario, costs her money. The way that the stuff with that money that she ghosted could go, that could cost her freedom. So we'll see how that goes. I mean, these people are in lots and lots of
Oh, yeah.
trouble.
Oh, yeah, absolutely. And basically, if Fed 2 hadn't happened, I don't think Bruce would have suggested that she declare bankruptcy. And
Nope.
bankruptcy catch them, and bankruptcy is what's going to get them out of Jeremy's life, because she's going to lose that property.
Yep.
She can't stay there.
You
So
know,
that was all he wanted.
I'm disturbed by something. So I keep reading on, like I've become really interested in the idea that Paint Chips has been riding the court, because we know that he's been open about it. He brags about it. Now the judge, neither Bolitho nor Hinkle have ever turned anything over and noted that that's happening. And the way that I read that in Florida, that's a big no-no. There's the canon, 37B. Like, in reading that, it talks about how, you know, a judge shall accord to every person who has a legal interest in the proceeding or that person's lawyer right to be heard. You know, it talks about also ex parte communications when they come in, how that should be turned over. And in the reading of this, it talks about how the staff for the judge is an extension of the judge. So there is no way that it doesn't matter if it just landed with staff. You know, he still is supposed to disclose that. And there
Well,
are
and it's
specific,
supposed to be docketed also.
yeah, and there are specific statements, like the statement about Dan Owen, that I found very troubling in his ruling.
I
There should be
agree.
no. I mean, that's crazy. Like, him to reference that period is wild. But you have to then question, like, where did he hear that from? You know, we've been talking about this, man and I were talking about it. And it's like Paint Chips. Paint Chips was writing letter. I believe that some of the stuff that he has stated, I believe he has stated things with, you know, that have come from Paint Chips, and he did not disclose that. There have been so many things that Bolitho has done in this. Now, again, I don't know the direction Randy will go, and to be honest, I don't know if you can. Fed 1, I think it's gone far enough that Bolitho would have a problem standing in its way. But Fed 2, I don't think you could get Fed 2. He's from go made statements that were really troubling. You know,
Well, yeah, we're going to get to that too. It's in there. Bolitho actually references the problematic statement that he made, and when he did make it, when I read it in the transcripts for one of those Pensacola hearings, I went, "Uh-oh,
yeah,
he doesn't want this case." And I think that's when he made up his mind that Jeremy Hales was going to lose this case if he
Yep.
filed it.
Yep.
And I think it's maybe an important lesson that if a judge tells you don't go this route, don't do it, because not with that judge.
Yeah, not with that judge. That's the kicker there.
Yeah.
You know.
Maybe
Now there are
we're trying
plenty of things like Lisa's still not out of hot water. There's another method. See, she's made a huge mistake as of late. I think a really good way to go after these people. Lips is in the fryer. You know, Lips has stated some pretty horrendous stuff, and Lisa has picked up every single thing that she said. One of those things is one of the worst allegations that you can make about a person. So, you know, with this, I believe that they'll get worse. I think they'll figure that this is carte blanche. They can do whatever they want, and with prejudice, the kicker with that too is, you can't bring these specific claims again. that doesn't mean you can't go after these people again. So,
Yeah, right.
you
That's
know,
true.
I think you
They've given
regroup.
him plenty to go after. I mean, Lisa keeps on repeating all of these lips allegations.
The essay stuff, that is the worst. And, going on. And I mean, they've done dozens of hours dressed as quote unquote mushrooms. They talk about it all the time. In every live stream, and they've dropped the facade of mushroom in some of the live streams. They'll talk about what it is. So
That's
I mean,
gross.
yeah, just straight
But I
up.
mean, that's not even really the thing you could go after her for. What you could go after her for is accusing him of SA.
Yeah, well, it all goes together. With them, they're not only accusing him of it, but they're using it to not just vilify and to mock, but I mean, it's damage. It is truly damage. That is, again, it's just like with the signs. They noted, accusing somebody of, being a predator, let's just say, regardless of what type of predator, that is bad. And that it jumps the whole damage claim. So you don't have to prove damages with that at all, because any reasonable person infers that will damage you.
Mm-hmm. Right. All right. We have a lot to get through. I don't know if we're going to get through this entire complaint, but we are sure going to try. Tug is not going to read tonight. He's going to conserve his energy. So I will be reading, which is great because I can speed read. Whereas Tug, on the other hand, talks as slow as molasses in January. So this will work out, I think. I think we might actually get through it this way, Tug. We might.
I doubt it. You'll hear this every now and then too. This stupid thing keeps coming on and taking my blood pressure. It's like, so I keep muting it out.
That's all right. I hear it, but it's not that. It's not that like
It's still crazy. People are asking him. I'm doing better, but they told me so. I've been taking a medication that holds up salt and everything. It forces your blood pressure up, right? And then on top of it, I'd been prescribed salt and other things. And then they gave me a new medication on top of it. So when you put all of that stuff together, what happened? Well, it took my blood pressure and it sent it through the fucking roof last night. And it hit me right in the middle of a live stream. And it is still up. I mean, it is.
Wow.
It isn't happy. So...
So Tug's going to take it easy. He's kicking his feet up. He's going to just lay back and comment. But I'll start reading this. Those of you who are here, by the way, there are 2,100 of you here. Thanks for being here. Make sure you hit that like and subscribe. Those things are totally free, by the way. Helps the algorithm. It helps the channel. And I truly appreciate each and every one of you for being here. If you want to support the show and make the haters crazy, you want to make them upset, then keep sending super chats and super tips. Go to supertip.gg/Megan Fox. It is pinned to the top of the chat. You can do that. You can also visit, if you want to help me out with my massage fund, you can go to Cash App or Venmo and drop a tip there as well. I use both of those to pay my masseuse. And I need it. And I need a masseuse after the last couple weeks I've had. Oh, the Spawn update. I know all of you want to know how she's doing with her ACL replacement, or what do they call it? Reconstruction surgery. Yeah, I guess it's a replacement. It was a horrible 4 days after Thursday. An absolutely horrible 4 days. My poor child. When your kid is crying and the meds aren't working, and we had to switch meds once and up them, a couple times to get the right pain management. Man, that was rough. I will tell you, it was rough. So, but we got through it, and she is doing her PT exercises already. She's getting up and around, able to get herself to the bathroom and back, which is great.
That's good.
So she's doing much better than she was even yesterday. Good. So I'm very happy about that.
That's the way it needs. That's how, you judge it every day. If it isn't
every day is a little better. Yeah. Mm-hmm. Unfortunately, Fairy twisted her ankle yesterday. So now I got two of them gimping around, and two of them to bring ice to every couple hours. And yeah, it just never ends here. It never ends. And now Mr. Fox has ripped his ACL and torn his meniscus too.
Oh no.
So he's going for surgery as well. and he'll be down and out for 2 weeks.
Megan, maybe
same-
you need a sign or something that says, do not tear your ACL, you know? Maybe you need to pull one out. I mean, you know, apparently people haven't gotten the memo.
I know. And we're all in PT together. I'm in PT for my shoulder. Fairy's in PT for her stuff. Spawn's in PT for now her knee. And now Mr. Fox is going to be in PT. The only one that's missing is Hangry. But we're going to pray real hard he does not have to go to PT also. So we're struggling over here, but we are back on the air. So thank God. So send the super tips. I could use them for the medical bills. All right, here we go. Report and recommendation. Plaintiffs commenced this case against 10 defendants, 8 of whom are proceeding pro se. The operative complaint is a sprawling 74-page second amended complaint with pages and pages of YouTube links that borders on a shotgun pleading. Now, I take issue with this. I take issue with this. It either is a shotgun pleading or it isn't.
Right.
Bordering on doesn't count.
See, the language like that really disturbs me with the judge, because you can't have it both ways. I remember, you know, it was kind of like I had a DA one time tell me that somebody had violated a protective order, but he was going to give them a warning. And I was like, there are no warnings in that. Either you do or you don't. You know what I mean? Like you don't get a do-over. So language like this, like, what does that even mean? Borders on? Well, it means that it's not one of those, so it's okay.
Right. So I don't know why you mention it other than to just disparage the plaintiff and his attorney. Right? I mean, and also the sprawling 74-page second amendment. How do you bring a case against 10 defendants without having it be about 74 pages?
Yes, 7.4 pages each. That's not bad at all.
That's not that bad. It's not. It's not that bad. Now, could it have been tightened up? Maybe. Maybe. But I mean, all of this is hindsight, right? I mean, I think, and we'll get there. Let's just keep going.
Do you mind if I derail for a second? I want to show you something that I saw today. It just blew my mind. So I was watching something.
The derailer.
Yeah, but I got to steal the screen because I've got to show you. It's totally nothing about that.
You have access to
I saw something on how different people do math, right? Chinese, how the Chinese do math. Okay. And I saw something and it blew my mind. Okay. I'm going to do my terrible writing on this thing.
Wait a minute. Do you want it shared? Because you haven't shared.
Yeah, show it. Yeah.
Right.
Yeah. Now I'm going to just show you something. It'll be real quick. It won't take long. Okay. Like the way you and I figure up something like 98 times 93, we go through this whole stacking process, right?
Yeah.
Well, apparently, like Chinese, they do a simple thing. They take how far away is 98 from 100? It's 2. Okay. How far away is 93 from there? And that is 7. You end up with 2 numbers, right? Okay. Mm-hmm. Now, this is wild here. All right. So these 2 numbers, when you put them together, they equal 9. How far away is 9 from 100? 91. So the first 2 numbers of this are going to be 91. Now, the second 2 numbers you come up with by multiplying these 2 numbers. So 2, 7, 14. So this, without all that work, it's going to be that. Isn't that crazy? Really? It works every time, man.
That is really weird.
It's right. It's totally right.
What if the numbers are above 100? Is this only works up to 100?
Well, you can still adjust. You just have to, go with different totals. But it's just wild that works. I was like, no way that works.
I've never seen that before. Is that like new math?
No, I mean it's just some different. Every group of people. You notice every age group has a different way. We have new teaching styles now. You have every country has a different. But I liked that.
God, I was so glad I'm not doing
that is
math
some
anymore.
Simple ass stuff.
So glad I don't have to do math in school anymore. I was so bad at it.
I've been showing the kids, and I've been looking for methods that I can show them that'll jump over that.
Yep. Hey, anything that works. When my kids started learning that new math or whatever they're doing, the Common Core math, it made sense to them. So I didn't get upset about it, even though I didn't get it. because they did, and they can do math in their head much easier than I can. So I think there's something to it, the different tricks, etc. All right, anyway, math gives me a headache. Plaintiffs allege violations of the Lanham Act along with various state law claims. Currently before the court are motions to dismiss filed by 8 defendants, and now we have a footnote. Defendant Preston filed a motion to dismiss, but she subsequently declared bankruptcy, Doc 92. The bankruptcy filing resulted in this case being stayed as to Defendant Preston. Thus, Defendant Preston's motion to dismiss is not currently before the court. Also not before the court today is the motion to dismiss recently filed by Defendant Luthman. The clerk of court had entered a default against Paint Chips. Paint Chips has now appeared and moved to set aside the default and sought dismissal. Plaintiffs have just recently responded, document 158, and the court, we got to go down here, will address Defendant Luthman's motion at a later date after having had time to study the issues raised by the motion and the response. All right. Plaintiffs have responded.
Do you think they'll do anything to Paint Chips, though, honestly?
I think he's going to have a much harder time dismissing the claim against Paint Chips for the sexual cyberstalking thing.
Yeah, but
I think he'll have a more difficult time. That doesn't mean I think he can't get around it. I think he will have a more difficult time looking unbiased if he dismisses it. So, yeah, I don't know. But who knows? This judge has not failed to disappoint me yet. So I feel like he will live up to his reputation. Plaintiffs have responded in opposition to the motions to dismiss. For the reasons below, the motions to dismiss should be granted. Plaintiff Jeremy Hales owns and operates a business that generates revenue by posting content on social media websites like YouTube, Facebook, and TikTok. Plaintiff Hales has over 730,000 subscribers for his What the Hales channel on YouTube and over 327,000 followers for his What the Hales page on Facebook. Additionally, Plaintiff Hales sells stuff. He finds in storage units.
Sells stuff.
He sells stuff.
Oh, yeah.
What kind of federal magistrate uses the word stuff in his filings? He sells stuff. What is that? Is that a legal term?
That is amazing. I have to pause right here and commemorate that. That is
he
such
sells
a command
stuff,
of the
folks.
English language.
Jeremy Hales sells stuff. Like, would it have been so difficult to type items he finds in storage units? No, it's stuff. Dude, come on now.
Yeah, if we would have gotten a dude in there too, that would have been amazing.
Yeah.
He
He sells stuff,
in
dude.
there, dude.
On an auction website called Whatnot. Defendants are various individuals scattered throughout the United States who Plaintiff Hales claims have joined together to form an anti-What the Hales media ecosystem. Oh no, this is not just a claim that he makes. They literally wrote it down. This is what kills me. It's in writing. We are forming an anti-What the Hales media ecosystem to destroy his YouTube empire.
It's not a nickname,
Yeah, it's not a nickname. It's a name they gave themselves.
Well, you know what I'm learning from this? Maybe I can form an anti what the hell's media ecosystem.
Yes, that's what we're learning, is that you can just go after anybody for anything for however long, till the end of time, do whatever damage, and no one can stop you, I guess. This ecosystem allegedly exists to harm Plaintiff Hales' businesses. No, they actually said that. They said that's why they exist. 2 of the defendants, Preston and Cook, live near Plaintiff Hales' vacation home in Florida. Okay, it's not a vacation home.
See, that's
his business.
They live there right across from it. See,
From
right
his
away,
business.
this is a problem. Right away, this is a problem. It's not a vacation home.
It's not a vacation home. It is his business.
Yes, which they take pride in taking pictures of and watching him go to and fro to work. And
Yeah. In this lawsuit, and then we have a number 3 footnote, Plaintiff Hales has another lawsuit pending in this court against defendants Preston and Cook. Additionally, Plaintiff Hales filed a different lawsuit in this court against a state court prosecutor for allegedly not enforcing a civil protection order against defendants Preston and Cook. Chief Judge Windsor recently dismissed that case for failure to state a claim. Why is he mentioning a case that has nothing to do with this one?
That
Any idea?
Well, it's I believe. Well, I believe, yeah, it's been brought up by someone else.
Well, I do believe it was brought up by the ecosystem in their emails to this judge.
Why has he brought it up though? Well, I have some not so flattering opinions on the communication between also judges, prosecutors, and all of that, and the biased way that they approach people.
It does kind of infer that this judge is upset that Jeremy Hales is going after the system. It does. It does appear that way.
Smells like it.
It sure does. So what you're saying here, Judge, is that you're keeping tabs on what Jeremy Hales is doing in other cases, and you don't like it. Or that because you're saying here that because one lawsuit he filed in an unrelated case was dismissed for failure to state a claim, that somehow you're sure that this case is also failure to state a claim. That's how it feels. Which, well, you are
even
not
more than
related.
that. Am I not allowed to exercise my rights and go out and redress my grievances with my government? Because I'm allowed to do that not only with speech, but if they step out of line, I am allowed to sue them. Again, that is a fundamentally protected right to step in and even comment on that, period. What the fuck? What does that have to do?
What does that have to do with the price of rice in China? Nothing. It has nothing to do
and
with
all of it does. The one thing it does have to do with, it's been a consistent thing. He's saying, hey, look, these people right here, they defame me. They put out these signs. They've stated crazy shit. People will not do anything about a protective order, although there's an Ohio court that has said there is violations, multiple ones. These people right here, behind the scenes, though, they're saying, no. And then these other people have joined in. It is all commonly joined. It's not like it's some insane freaking narrative that's coming together.
Yeah, not to mention that just because that case was dismissed does not mean that the prosecutor and the sheriff were actually upholding the protective order, because they weren't. They didn't. The court is just saying, we don't care. We don't care if he did it or not. Like, we don't care if they upheld it or not. He's got immunity. It doesn't matter. Period.
That's actually what their argument was too. Their argument was, I don't have to care.
Yep.
Thank you, judges, too, for upholding the idea that I'm sure, like I said, if you really want to bring that up, the way you really address it is you bring it up to voters, because these people have to run for fucking office.
Yeah.
And that's how you bring it up.
Let me address this. By Emily says, personally, I don't believe throwing barbs at the magistrate is the way to help Hales' case. If this gets reversed, the case is going straight back to him. Let me address this. First of all, I will never, ever, in my entire life, ever be able to withhold my opinion on judges when they behave badly and what they're doing, no matter what case they're working on. I am not Jeremy Hales' lawyer. I'm a journalist. I'm allowed to have my opinions on judges in cases that I work on. And I don't take into consideration, it doesn't cross my mind that, something I might say would harm his case somehow. I'm not a litigant in this case. This judge he is a public official. He has there's every right. We have every right to criticize him in any way we want. Period.
This judge has allowed this courtroom to become a clown show. He's allowed people like paint chips to operate with impunity for how long? I mean, he was writing and calling him an alligator effer. They were like, no, don't do that. He did it again. And they were like, no, don't do that again. Now you got these John Doe filings coming in. You got paint chips writing. They're not disclosing it. All these things are problems. These are huge problems. Like I said, I don't understand how I've been reading because I get stuck on these certain things, these certain factors, and I cannot for the life of me understand how a state court can say, hey, we need to disclose these letters that Bruce Manskin, like imagine this were reversed and Bolitho, maybe he did write Bolitho with this. I have no idea. You know, I'm not saying he did or anything, but they've turned over no communications. And we know for a fact that Paint Chips was writing them because he sends them to everybody. and at first, we were all like, maybe that isn't the right address. So we looked it up and it absolutely was. He didn't just write Bolitho, by the way. He wrote Hinkle too.
Mm-hmm.
So both of them, I mean, this should have been.
They have an obligation to docket those emails.
Yes, disclose and docket.
They're not on the docket. So why? Why is that? All right. So let's continue. And yeah, I'm never going to stop saying, oh, Hurricane Von Hurricane, please keep super chatting me with your troll comments. I love that. Pay me to say this shit. Absolutely. Cope. Listen, Hurricane, it doesn't bother me at all. You can send these all night. At some point though, I'm going to ask you for $5 or more to read them out loud. But feel free to continue to send your weird troll statements with super chats. That is the only way you're going to get any attention. So I'm glad you figured it out. Thank you for donating to the Me Fund. So here's the thing. Let's keep reading this. Plaintiff Hales alleges that defendant Preston is liable for malicious prosecution and civil conspiracy, counts 1 and 8, and that defendant Cook is liable for civil conspiracy, count 9. One of the other defendants, Matskin, is an attorney from Massachusetts who previously represented defendants Preston and Cook in one of the other federal lawsuits filed by Plaintiff Hales. Plaintiff Hales alleges that defendant Matskin is liable for tortious interference with business relationships and civil conspiracy, counts 5 and 7.
Is that mentioned, the first part about him being a previously defending them? Is that mentioned in the lawsuit itself? That's just information he decided to just throw in there and
put that in there.
Fed to.
Yeah, I think so.
That has nothing to. Again, these seem like problems to me. You know. Again, yeah. Because he's mentioning it, and he mentioned it earlier on. He talked about this same thing earlier on. He talked about the fire. In fact, he went further with the prior representation. He went further and tried to offer court funding to any lawyer that would pick up, which is highly, highly irregular. I've never seen that happen. So, I mean, when this kind of, I believe, like I've been saying for a while.
Not to mention, he sanctioned Randy, promised to sanction Bruce, and then never did it, and allowed him to not show up, to disobey his direct orders. Unbelievable what he allowed. Unbelievable. And yeah, you're right. That's a good catch, because I don't think that was in Fed 2. That Matskin was their previous attorney.
That's the problem with him being the magistrate over both cases. Unfortunately, if he has a certain mindset, then
Yeah. Defendants Helm, Hughes, Teschendorf, Lee, Kesey, Raymond, and Luthman are all people. Well, that's debatable. Most with their own YouTube channels, who Plaintiff Hales says have engaged in a civil conspiracy to harm his businesses. Defendant Lee is also alleged to have violated Florida's Deceptive and Unfair Trade Practices Act, the Lanham Act, and to have tortiously interfered with business relationships, count 4. In addition to civil conspiracy, defendant Luthman is alleged to have violated Florida's sexual cyber harassment law, count 16. Now, this is very snarky. I don't appreciate this sentence either. To help keep that all straight, here's a chart. Here's a helpful chart if you can't keep up, folks. Do you feel the sarcasm dripping off of his words?
Yeah. Yep. He also is, with this, you can only do one thing to people, right? It's so bizarre.
Yeah.
Considering, Fed 1, there were 3 claims, 2 survived so far. Out of that, multiple claims.
Also, yeah, it's a good point, chat. Bolitho took forever to respond to this. He has been
Yeah,
slow
he let it.
walking this for
That,
ages.
that's actually a very good point. If he could have responded for the longest time with this. If he felt that this was a garbage claim, he could have looked at this and not bled the guy for six figures. That
Yep.
while they're playing service
Well,
games.
meanwhile, he's trying to serve these people, spending thousands of dollars doing it, and the judge was planning on doing this. Why on earth didn't he just dismiss it or write this months ago, before the repeated attempts at service, in fact, do you think that he knew that he was going to be doing this when he got into that big argument back and forth about Teschendorf?
Yes, I believe that he knew he was going to do this since he mentioned Bruce in the very beginning.
So do I. And I think that it's absolutely irresponsible and wrong that he cost Jeremy a bunch more money, thousands of dollars, while he tried to serve all these people. In terms of relief, plaintiffs seek monetary damages against all defendants. Plaintiffs also seek injunctive relief against defendant Lee and Luthman. Procedural history. The original complaint in this case named some of the current defendants, but not all. The claims in the original complaint were defamation, civil conspiracy, tortious interference, and aiding and abetting. Defendant Helm filed a motion for a more definite statement, which led to the court ordering Hales to file an amended complaint. Plaintiffs then filed the first amended complaint. Plaintiffs later filed a second amended complaint, which named the current defendants and asserted claims involving civil conspiracy, tortious interference, FDUPTA, and Florida's sexual cyber harassment law. It is the second amended complaint that defendants now seek to dismiss. Discussion. In the pending... Did I miss the fourth? Where's the fourth? Oh, I missed the fourth one. Here it is. Defendant Helm filed a motion for more definite statement, and the court ordered Hales to file an amended complaint. We have a footnote. In granting the motion, the court instructed Hales' counsel that he should familiarize himself with the 11th Circuit's precedent on shotgun pleadings before filing the amended complaint. Okay, again. So he's saying, I warned you, but this document does not say that his amended filing is a shotgun pleading. Right. It says it borders on it. So that means it isn't one. So why are we mentioning, I warned him?
He's essentially saying, though, should have gone after two people. Shouldn't have gone after Bruce. Should have gone. I mean, it's so bizarre. It's so bizarre.
It's all right, chat. Let the trolls pay to troll me. That's great. I encourage that all day long. I will take it all day long. I will take your money. So you just keep on doing it, trolls. In the pending motions to dismiss, defendants argue that dismissal is warranted under the Rule 12(6)b or 12b(6) of the Federal Rules of Civil Procedure for failure to state a claim on which relief can be granted. To survive a motion to dismiss for failure to state a claim, a plaintiff's complaint must contain factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. Threadbare recitals of elements of a cause of action supported by mere conclusory statements do not suffice. Now, this is where you need a legal education to understand what these words mean, because this is what makes it difficult for lay people to understand, because we're not steeped in legal terminology, right? So when they talk about conclusory statements, those would be legal conclusory statements. That's not allowed. You're not allowed to make a legal conclusion as an allegation and that be, well pled. You also need to do certain things for federal standards, which are different than state. So this is going to come down to what the judge is saying is a procedural error. A court ruling on a motion to dismiss must accept the complaint's factual allegations as true, but legal conclusions are not entitled to the presumption of truth. Defendant Lee's so in other words, a legal conclusion would be Bruce Matskin tortiously interfered with Jeremy Hales' business. That's a legal conclusion. That's a conclusion that a jury would have to come to, right? So that's in order to make the claim, you have to say, here's how he interfered with his business, how much money he lost, and what the ramifications were, I believe. That's what I understand it to be. And I think that's what the judge is saying he wants or wanted. Defendant Lee's motion to dismiss. The court will first take up Defendant Lee's motion to dismiss. As mentioned above, the second amended complaint alleges that Defendant Lee violated the Lanham Act and the FDUPTA tortiously interfered with business relationships and participated in a civil conspiracy. That plaintiffs have failed to state a claim for each of these causes of action. In count 2 of the second amended complaint, plaintiffs claim that Defendant Lee violated the FDUPTA Florida statute here. Plaintiffs seek damages and injunctive relief as well as attorney's fees under FDUPTA. Defendant Lee argues that dismissal is warranted for failure to state a claim, and the court agrees with Defendant Lee. And there's a footnote. The parties disagree over whether claims brought under the FDUPTA are subject to the heightened pleading requirements found in Rule 9b of the Federal Rules of Civil Procedure. There is a dispute among the district courts in Florida on this issue. And then he cites case law discussing the split. It is unnecessary to weigh in on that dispute today because the FDUPTA claim does not survive under the normal pleading standard found in Rule 8. Okay. The court will first discuss plaintiff's claim for damages under the FDUPTA. To assert a FDUPTA damages claim, a plaintiff must allege 1, a deceptive or unfair act in the conduct of trade or commerce, which I believe he did. 2, causation, and 3, actual damages. Although a plaintiff need not be a consumer to assert a FDUPTA claim, there must be an injury or detriment to consumers. A plaintiff may only recover actual damages under FDUPTA. The state does not allow nominal damages, speculative losses, or compensation for subjective feelings of disappointment. The phrase actual damages in the FDUPTA context is a term of art. The sole permissible measure of actual damages is the difference in market value of the product or service in the condition in which it was delivered and its market value in the condition in which it should have been delivered according to the contract of the parties. The phrase actual damages for FDUPTA purposes does not include consequential damages or lost profits. Dismissal of a FDUPTA claim is warranted if the complaint fails to plausibly allege actual damages. And then he cites another case affirming dismissal of FDUPTA because the plaintiff has not pled a plausible claim for actual damages under the FDUPTA. Looking to plaintiff's second amended complaint, it fails to plausibly allege actual damages caused by Defendant Lee's violation of FDUPTA. Indeed, plaintiff's claims are ill-suited to the requirements of the FDUPTA because this case does not involve a product or service, much less a delivery of that product or service in a manner that was not contemplated under a contract. I think this is all very...
Isn't... This is where we get into some strange... I'm wondering about product and service, like how it's defined. Because again, okay, if I'm buying memberships, I am buying a product or service. And the delivery, there have been judgments. What I'm getting at on this is there have been judgments that have talked about everything from electronic delivery of movies to things in apps and more, so the idea, it doesn't have to be like a product that I hold in my hands. And that's how I feel like when they're talking about this, it feels like you're talking about an old school definition of product or service,
Yeah, and it's interesting because at the beginning of this, he claims that Jeremy Hales has a business by posting on social media. So it is a business. It is, so there must be a product and a service. You know what I mean?
Mm-hmm. Yeah.
Like,
and
in this paragraph, there's no product or service. Like what? How does he have a business on social media? I don't understand.
I don't know. My problem is with the Lanham Act. I do not know enough. I mean, the Lanham Act is such.
Right. I don't know enough about it either. Yeah. And it's real. I tried to read it too, and it was like, ugh. It was like,
it's just a bunch of,
it's so boring.
It's not just that. Okay, if it takes somebody that's hyper specialized, this is one of my problems with judges. It takes hyper specialized lawyers to argue these things, but you get the same judges for everything. So you're going to tell
Right.
me the same judge somehow knows everything, that it takes like this hyper specialized person, to
Yeah.
truly know about it? That doesn't make sense to me.
Well, and also, I mean, and this could be a pleading issue. Lisa admitted to contacting Olight. She published letters that were written to Olight, trying to get Olight to drop Jeremy Hales, which they did. They did drop him. And I don't know if this was a pleading issue, that it wasn't stated that, okay, she contacted Olight and tried to damage his business, and then was there a mistake made in not continuing that thought and saying, and as a result, Olight
this
dropped
damage was
Jeremy
done.
Hales.
Yeah.
Because it's not like these things didn't happen. They did. They happened. So is it because, is this a technical issue? Like it just didn't go far
It
enough?
sounds like
to
they're saying
explain
that
what the
there's
harm was.
See, that's the problem. I don't know enough about the Lanham Act to say, is this a technical issue, or is this the wrong approach? Like what, again, by his thing, again, I can't say regardless one way or the other, but what he's stating, I can't judge it on the technicality. Again, even with lawyers, I talked to a couple of lawyers with Lanham Act. They're like, nothing about that.
Yeah, we've got Bruce stalking YouTube's lawyers, finding their home email addresses and home phone numbers to
Contacting
discuss.
whatnot.
No, I'm talking about YouTube.
Yeah, but I'm saying, and contacting whatnot.
And contacting whatnot. And I mean, maybe it wasn't enough to say he did these things. You needed to go further and say, and here was the result and the damage that was done. That's what I'm getting out of reading this. We'll see when it comes. We get to it.
I also wonder about. See, we have this new thing that has come up in the last, especially decade. We don't have storefront anymore, because if you think about the parallel in real life, like if you were to do this stuff as a physical store, how would law enforcement plus the judicial system, they have a much different view over it. If you're stalking a freaking, a physical place, and, you're interfering with their ability to restock or do this or do that, that'd be something else. But I don't know. I feel like there was a channel that talked about, God, I'm trying to remember their name. They were talking about the rules on cell phones and how your right to repair. Essentially, a lot of people don't understand. Like, when you find like a free how to repair your iPhone or something, it's technically illegal to put out things like that. If somebody, people have gone to prison for that kind of stuff. But the laws on that, the reason it stays like that is because the laws are almost 3 decades behind where we are technologically. And you have to wonder sometimes with some of these rules too, are the laws, first of all, behind, or is it the judge's understanding of things? Is that also drifting into Vic Mignogna, which you brought up? Vic Mignogna judge compared reposting claims of ARP, taking and reposting something to reposting images of kittens and puppies on Facebook.
Oh my God.
Yeah.
Are you kidding me?
I'm not. I was like, wow, what?
That's terrible.
Yeah. But anyway.
This is a good comment here by Jack Miles. Guess who told Jeremy to file another case?
Yep.
Bolitho. That's right. Because they tried to add the defendants to Fed 1.
Yep.
And Bolitho said no. He wouldn't allow them to. He told, and when Randy asked him, well, what are we supposed to do when this, attorney here is acting in the same way as his clients, and now he's defaming, now he's doing interfering with his business, he said, file another case. So this judge told him to file this case. Unbelievable. It's unbelievable to me.
What I love about all of this, though, is the Fats, and all of them have been claiming that they were going to sue Jeremy Hales for essentially the same things.
The same things.
Yeah. So
how's that going to work out for you?
Yeah.
Go ahead.
Well, and it's also, okay, the message here. The message is an interesting one. See, Jeremy Hales went through the legal law enforcement apparatus, instead of taking, say, 700,000 people and crushing the shit out of a freaking 3,000 sub channel, which, again, that's a discussion for another day. And I'm not saying that anybody's threatening to do anything there, but he decided to go with a different mechanism, and he could have gone with another mechanism, I suppose, and again, I think the message that's being sent is, well, when people are saying they're going to destroy your empires and destroy your businesses, apparently that's okay. That's what we're being told.
Yep.
So,
Yep. The second amended complaint simply states in conclusory fashion that defendant Lee's deceptive and unfair trade practices caused plaintiff to suffer actual damages. But such conclusory allegations are insufficient to state a plausible fiduciary damages claim. Again, I think that what they would have wanted is for them
actual
to
damages.
identify what was the deceptive and unfair trade practice and how did it cause damage and how much damage did it cost.
Do you have to do that in the initial
I
pleadings, though?
think so. Well, that's what he's saying. Okay, that's what this judge is saying. I don't know. I can't answer that question.
Yeah, is that something that's specific? Because with other types of claims, you don't have to do that. That's something you get into discovery and all of that, and then you showcase it. So I'm wondering if that
Right.
again, I don't
A
know
lot
enough
of this
about
stuff, of course, could come up in discovery, and so you do have to wonder, like, well, then how do you get to discovery if you're
Well-
supposed to have all of this stuff right now? I mean,
Yeah,
they need discovery to uncover many of the emails that were sent that we don't know about.
Well, and on top of it, we talked about this. Like when the judge looks at something, they're supposed to look at this and deciding whether it's going to go forward or not in the light most favorable to the plaintiff.
Mm-hmm.
So, I mean, when they're looking at it again, and again, maybe the Lanham Act brings something into it that's different. I don't know.
Right.
I
don't know either.
If anybody knows a lawyer that's very familiar with that stuff, I would be curious to talk to them about all of that.
Yeah, I would too. Especially, I think what we're running into here is federal rules, and federal rules are different than state rules. And so I'm not all that familiar with federal rules, but I do think that we'll get the answers that we're searching for as when we get whatever Randy's response is, then we'll understand that. I mean, Randy's been practicing in federal court for a long time, and I'm sure he knows the answers to those questions.
What amazes me is yesterday as well went very bad on the bankruptcy front. Very bad,
Very
Yeah.
bad for Lynette.
Lynette, that's what I mean. Yeah, very bad.
Yeah, Jeremy had
And
a huge win in bankruptcy.
yeah,
Now,
I mean,
you can't be feeling too bad about this because the truth is he's still got all these people tied up in
Not-
ways
not
where
just-
they're not getting out.
not just that. Okay, this case right here, if they really wanted to, if this was going to be the decision there, if it would have held in, you're talking about a case. There's no way Jeremy wouldn't have spent $500,000 on this case by itself. No way. I mean, already before when you're just serving people, it's costing you 6 figures. Going through discovery, that would have been a very expensive. So, I mean, again, they may decide to keep it too. So when I talk about it, I'm not saying it will not, that Hinkle will not decide something in it, but at where it is, I mean, again, it's a very expensive case. These people, without this though, like you said, bankruptcy would not have happened. Lynette, basically, they told her to back herself into a corner and burn everything she owns to the ground. And you also had Bruce because of his because of how things were going, I suppose. Start writing to the courts in state court. He's in trouble with that. The bankruptcy has opened Lisa up for 100,000. These people are in some bad ways. And I mean, the stuff that happened in bankruptcy court, essentially, there's also the message that's being missed here. They talked about, the decision they wanted overturned, talked about Jeremy Hales being able to actually get damages from Lynette Preston. Now, they talked about entitlement, not the costs. The money factor will be decided after the bankruptcy. Now that's a key statement in that because when you're saying it that way and the courts are agreeing, it seems to me that they're stating that, this whole idea of being able to write off all of these judgments and stuff that are going to come, whether they're ongoing or future or whatever, it doesn't seem like that the bankruptcy court is expecting that to hold either. Like, she's going to be paying money afterwards.
She's definitely in trouble. And I mean, they're trying to spin it like, oh no, it's not bad for her what happened in bankruptcy court, but yeah, I don't know how they're going to make that stick.
I mean, how does it not a bad thing? They asked for sanctions. They wanted to set aside the thumbnail decision where the judge comes in, says this stuff is frivolous, and there will be an entitlement to sanctions. They want it set aside because bankruptcy. Oh my God, how dare you? And the court was like, no, no, we're not going to do that. But in that discussion, there's two things that come up. The one thing that really is impressed upon me, and I wanted to talk about last night, I didn't get around to making this point. I guess I'll talk about it more tomorrow, is the idea, again, when they're talking about entitlement to sanctions after the bankruptcy, that court assumes, and it seems to me that the bankruptcy court is saying, yeah, they're right in this. There will be sanctions after. Therefore, all of this action that they thought they were doing, the whole point in the bankruptcy was to essentially, worst case scenario, trade her land to write off anything Jeremy could do. But if he's going to be able to collect sanctions and stuff from her, which he very well should be, because all of that stuff is malicious. Again, you can't write off things that are done with malice. She has a real problem.
Number one, Cat Whisperer has a question here that I actually can answer. It says, who's to say that Bolitho hadn't done any research himself and seen that Hales needs a stronger case for Fed 2 and did this for a reason? I can tell you, I can answer this, because he is recommending dismissal with prejudice. Which means that Jeremy Hales cannot ever bring these claims against these people again.
Yep.
So that's the problem. He's not giving them another chance. He's saying, this goes, I hate this case and I want it to die. And it's almost like a sanction against Jeremy Hales to say you can't file this again. With prejudice does not happen very often lately, I feel like. I mean, they didn't even dismiss the thumbnail case with prejudice. It was without. Unbelievably. Even though the judge later found it was a frivolous case, it still got dismissed without prejudice.
Right.
So what the hell?
Again,
this with prejudice thing is like, it's like a slap to say, we don't want to hear from you again. Go away.
Well, if they won't let, it's again with these specific claims too. So that's the kicker. It's not, you can't pursue actions against these people ever again. You just can't bring these claims. So
you can't bring these claims. Yeah, right.
I said, I think Lisa, personally, the worst things that she's done have happened after Fed 2. I think the worst things, again, I see a clear path personally to being able to round up a few of these, and it doesn't require Fed 2 at all. In fact, I think it operates better without Fed 2. But, again, I don't know what'll happen with Fed 2. And I'm not a strategist with the Lanham Act either, but I see a very good way that involves libs that Jeremy Hales can save himself a lot of money, in my opinion, and he can still take these people down.
Oh, they're still going down. I mean, Bruce is tied up in a practicing law without a license scandal, so he's going to be wrapped up in that for a while.
That was something funny too. We were talking about how essentially, like with Fed 2, how often have we actually talked about Fed 2 in a while? Because it's all of it has been about arguing service, Otherwise, nothing's happening there. Everything else you're covering. Everything else you're covering is bankruptcy. We're talking about the craziness other people do, documenting it and more. And you still have, like I said, ongoing cases. So, and the bankruptcy is going to, it sounds like, take a bit of time. Hales was talking about time frame yesterday. And with the typical bankruptcy, you're just talking about a few months. With this, and investigating and looking into property and figuring that out, you're talking about multiple, like I think he said something like 5 months or something. It was crazy,
Can
before
I
they come
just
back.
ask the trolls in the chat, please, for a favor? If you're going to troll, I ask that you just be legible. Please, can you write a legible sentence? This is not a legible sentence,
Actually,
Deftones Andy. I see Tug gripping onto content he won't have. LOL.
Gripping.
Deftones, this is not a complete sentence with a thought, a subject, a verb, and a point. If you're going to troll, you're going to have to do better than that. I have to understand what the trolling is. Is it too much to ask that you use proper English? And put
I
your
like how
sentences
all of
together?
these people, they abandoned Lynette Preston. They turned on her and abandoned her. Now they can all be like, no, we never did that, dude. They were talking about freaking having wellness checks on her. Freaking Lynette. I think I'll play about, like I said, 30 minutes this weekend. I'm going to play 30 minutes of her discussing Lisa, stuff that, again, pretty much you seal in the bankruptcy stuff, the money, donations, we the idea, they keep arguing this idea that they didn't do a fundraiser. And it's so insane to listen to, because semantically what they're doing is arguing semantics over that. And the courts, it's clearly defined in Florida what a fundraiser is, by the way. A fundraiser, first of all, I'll write this down, just give me a second. Fundraiser.
SF says, if you're going to troll, at least be funny. It's the least you can do, folks.
Yeah, be creative,
Please use actual sentences.
Well, I don't, spamming, no, like, again, people get banned over, you can have your opinions, that's fine. But like for myself, you get banned over spamming and some of the other bullshit some of these people were pulling yesterday, which I'll talk about tomorrow. But with the fundraiser, a fundraiser is noted as any activity where money or items of value are solicited or collected for others for a stated purpose, especially when the purpose is, and they give a few examples, like it's charitable, it's benevolent, for someone else's benefit, it's framed as helping, relieving hardship, supporting a cause,
like building a
etc.
fence,
privacy
fence, barn dominium.
Now, under there, for the legal backbone of it, there have to be 3 elements, which they very much hit. They have to have solicitation. Now, solicitation, the way it's defined, that would be included in asking for donations. When you're the way that they're posting links and stuff, that has been well defined. In fact, people have gone to jail for fraud over that. Live streaming. Also certain types of statements like every dollar helps, or support us, help this family, things like that. Again, solicitation, 100%. Number 2, a stated or implied purpose. So with that, the whole idea of helping this family, oh man, and not just for the house, building, bills, whatever, legal fees too. I mean, all of this stuff is fundraising. Now, again, the legal fee thing may be 100% above board. I don't know. They were at least a little more transparent on the collection and giving the money and paying it out, it looked like. But this other stuff, there was no transparency. And then the third element was that the funds, they have to come from others. And the reason for that is because you can't just say, hey, this is my personal crusade, or it's just, my personal income. Plus, if it is broadly solicited, you can't just say, oh, these are a gift between, or some kind of, again, contract on it. The excuses you can't pull out. When they were going through it too, it was saying, the excuses that don't work, saying things like it's just donations. That does not work. Donations make it a fundraiser. So it's so bad. Like this is the problem. If they get to walk on Fed 2, okay, but they still have some major problems out
Well,
there.
we never felt all that strongly about Fed 2 to begin with. We said from the beginning it was going to be a long slog up a high hill, and we didn't know if it was going
I
to
didn't
get
feel good
to
about Fed 1.
trial.
Like we didn't cover Fed 1 at first, and we've talked about this before. I was shocked. We had started talking about it once we found out number 1. I thought it was just a tortious interference claim. So that tortious interference is notoriously
It's very
difficult.
hard.
Yeah, but the claim actually survived and went forward. I honestly thought Fed 1 before.
And I think if you get that Fed 1 in front of a jury, I think she's cooked.
Oh man, yeah. She's
But Fed 2, on the other hand, I wasn't sure if it was ever going to get past the motions to dismiss.
Well,
and here we are.
We talked about potentially weak links on there too, because I think you could sit down and describe to people how certain people fit in, but how do you frame that in legal documentation? How do they work in a conspiracy? How do you lay it out? And certain people, we wondered if they would be survivable or not. Just in like, say, the whole thing holds up and you're picking or choosing. Some people, I thought, well, best case scenario, some people are going to drop off, you're going to lose some people. But unfortunately, one of the things that worried me from go is the discussions about Bruce. We've talked about appealable error that has come up for a long time in this case. And a lot of it, again, just the way he's talked about Bruce, the framework, the way that he essentially framed this as a dispute because the guy was the lawyer for opposition. And he brings this up in here. He frames it. He doesn't go as far as he did when he was talking about it before, but he still brings up the fact that the guy was formerly the lawyer for these other folks.
Mm-hmm. Yeah, it's weird. All right, getting back to this here, we're on page 9 of 45. We're doing well.
Yeah, actually, I think we're doing a lot better than
I think we are doing well.
Yeah.
Plaintiffs claim that they are entitled to $959,000 in damages for the alleged FDUPTA violation, but the second amended complaint fails to explain how that amount constituted the difference in market value of the product or service in the condition in which it was delivered and its market value in the condition in which it should have been delivered according to the contract of the parties. Again, I think this is putting a very specific definition onto a new type of business, right? YouTube is not, you can't squeeze YouTube into a generic definition of what business is. And again, this could be a FDUPTA thing that I don't get, but it doesn't seem to me like there was an argument that there was a different market value of the service or in the condition it was in versus the market value in the condition in which it should have been. That wasn't the argument. So whatever. Similarly, plaintiffs' request for injunctive relief under the FDUPTA should be dismissed. In the FDUPTA context, injunctive relief is not a standalone cause of action. Lots of case law. Rather, it is a remedy for a violation of FDUPTA. To state a claim for injunctive relief under the law, a plaintiff must allege 1, a deceptive or unfair act or practice in trade, and 2, that a plaintiff is a person aggrieved by the deceptive act or practice, and 3, looking at the first requirement, an act is not deceptive and a practice is not unfair unless a consumer was actually aggrieved by the act or practice. Although a non-consumer may assert that FDUPTA claim, the plaintiff must allege that the relevant act or practice was harmful to a consumer. Here, plaintiffs have failed to plausibly allege.
Do you have to show that from go? Do you have to show?
No, I think what he's saying is you have to at least state it. You have to state these customers were harmed and here's how they were harmed. I mean, it's not what he's saying. It's not enough to say customers were harmed or consumers were harmed. You have to say consumers were harmed and here's how they were harmed. They were harmed on this date in this way by this method as a result of what the defendants did. That's what I'm getting out of this. And I'm not saying that that's true. I'm saying that's what the judge is saying. And that's allegedly what he's saying here, I think. The allegations in the second amended complaint are about conduct by defendant Lee that was allegedly injurious to plaintiffs, not consumers. dismissing FDUPTA claim because the alleges were about conduct allegedly committed against the non-consumer plaintiff, not the unfair practices committed against consumers. Although plaintiffs have stated that the conclusion that the consumer was aggrieved, labels and conclusions in a formulaic recitation of the elements of a cause of action will not do. At the end of the day, the FDUPTA is a consumer protection statute that was designed to protect consumers from unfair and deceptive trade practices. It is clear. Well, first, hold on. Aren't the consumers harmed? Jeremy Hales' fans who have been led to believe that Jeremy Hales is a terrible, abusive person. And because of that, they gave money to a fraudulent fundraiser. Weren't they harmed in that way?
Yeah, but I wonder again, with the layout for this, I wonder if, I don't, like I said, Lanham Act. I don't know how you lay all of that in. I can tell you. Well, I mean, okay, we're used to covering like a tortious interference, something like that, right?
Yeah.
And when you lay that out, it's just it's an ABC game. A party, B party, C party interjects. They see their way into it. Oh, by the way, here's the thought I just had, it's slow in the uptake. The trolls there were talking about how content, right? They were talking about, oh man, content. We won't have, I could switch off to whatever, but I find this, and it'll go on for a while. The problem is going to be, what do they think is going to happen to the anti-Hales when there's no lawsuits anymore? None of that stuff. What happens to them?
Mm-hmm.
That's the problem.
Where are they going to go with their content after that?
Well, they're not likable. I mean, again, you're talking about,
and they don't cover anything else.
Yeah. So, I mean,
Amanda, I love this. So he complained about the length of the complaint, but he wants so much additional detail on the claims. That's what I'm getting. Yeah,
that's funny. Yeah,
that's what I'm getting too. That's my guess at what this means. Anthony the Warrior, member for 2 months, says, Megan, the customers got hurt when they attacked Whatnot when they tried buying products for over $100,000 and not paying. That's a very good point. The question is, was that laid out clearly in the complaint?
Yeah.
If it wasn't laid out,
does it have to be laid out?
And does it have to be laid out? Right.
Yeah.
We have 2 questions here. Does it have to be? And was it? I don't think that particular claim was. We know these. See, this is the problem. We all know these things happened. We know Jeremy Hales was harmed.
Mm-hmm.
If the complaint did not lay it out in a way that showed that harm in a way that the federal court wants it, well, then this is what happens. Now, it is still possible that it's possible the judge is wrong. I don't know. And I guess we'll wait and see what Randy's response will be. It is clear to the court that the allegations in the second amended complaint are not aimed at vindicating consumers who were harmed by defendant Lee's conduct, because plaintiffs have not plausibly alleged a FDUPTA claim. The claim for injunctive relief against defendant Lee should be dismissed. 2, the Lanham Act. In count 3 of the second amended complaint, plaintiffs claim that defendant Lee violated sections 32 and 43 of the Lanham Act. The Lanham Act was intended to make actionable the deceptive and misleading use of marks and to protect persons engaged in commerce against unfair competition. Now, I do know that Randy disagrees with this reading of the Lanham Act. I did not have time to talk to him about exactly why he says that. But I'm sure that his response will talk about it. I'm actually going to skip this because I have nothing to say about the Lanham Act other than all this says is that it's supposed to be about trademarks. There was no trademark registration. This is not an argument about trademarks. And so we're kicking it.
Do people realize how often cases go to court too? Honestly, so for civil cases, now again, statistically, this includes settlements and more, but you're talking about only 1 to 2% of filed civil cases are ever heard in court.
Mm-hmm.
Right. The other 90, high 90s they're settled somehow before a case is ever brought. So, you're talking about like in this portion here. So, again, you're trying to bank for the, I'd have to look at the percentages on how many again settle before that to see how much elimination. But you think about that. I mean, if you're banking for 1 to best case scenario 2%, that's unreal.
So to wrap up this part of the argument, I'll read you the last paragraph. It says, to succeed on a claim under this code, a plaintiff must demonstrate 1, that its mark has priority, and 2, that the defendant's mark is likely to cause consumer confusion, basically like reusing someone's logo, misleading people with a logo. Although none of that was alleged, and I don't know where this trademark argument even comes from. And then a footnote number 6 says, this arguably makes plaintiff's second amended complaint a shotgun pleading, because plaintiffs are asserting 2 separate legal claims in the same count, i.e. a claim under 15 U.S.C. 1125 A1A and a claim under 15 U.S.C. 1114, stating that a complaint, and see this case, stating that a complaint is a shotgun pleading if it does not separate each cause of action or claim for relief into a different count.
Arguably makes it so. Again,
so there's an argument that it doesn't.
Yeah, again,
I'm hearing.
Again, so he's making an argument stating it could be.
Mm-hmm.
Not
is.
That it's so insane to have a judge, say, well, some people might say this is.
Yeah, Wolfgang, yes, what the Hales is trademarked. That's right, but there's no allegation here that the Fleas took his trademarked what the Hales logo or trademark and did anything with it to mislead. There's no accusation there.
A funny thing
about that. About the trademark.
A funny thing with trademark that, like, you remember when Lips and then we're talking about SEO, they don't understand that, they were worried about trademark, prior use trademarks, like where you've gone out and you have your channel and everything else, you have your own logos and stuff, prior use. You can go after somebody for damaging even with prior use claims too. So even if you weren't trademarked, he's trademarked by prior use.
Mm-hmm. All right. So then the last sentence here is, nonetheless, the court would prefer to resolve this dispute on the merits instead of shotgun pleading grounds. All right. This is still about trademarks. We really don't need to read this because honestly, it doesn't apply. This is all about trademarks, which the complaint does not allege any trademark confusion. So I do not know why this is going on and on and on about trademarks. I really don't. I think it was a misreading of what the complaint said. And it's silly. I don't understand this part at all. And I'm not going to waste all my time reading it. Please, guys, if you want to read this, please feel free to access those documents and read it. But I'm not going to waste 20 pages on trademarks when this case has nothing to do with trademarks.
I put up a link for it yesterday on Facebook.
Oh, good. Okay. Tug put up a link to the document on Facebook. If you want to go and read these pages that I'm skipping, please do go. I'm not trying to keep them from you. I simply don't think it doesn't bring us any closer to understanding this order, this recommendation. It really doesn't, because he completes. This part might be important. Moreover, it is not this court's role to rewrite a deficient complaint or to guess about what claims a plaintiff, especially a represented one, intended to bring. Okay, that's fair. That's fair. Yeah. A claim should be written in a way that he can understand what the claims are. But I didn't have a problem understanding the claims. I don't know. Thus, the court need not address whether plaintiffs have plausibly alleged a false advertising claim, because the second amended complaint does not actually assert such a claim. Instead, it asserts that defendant Lee violated 15 U.S.C. 1114 and 1125 A1A, neither of which address false advertising. Nonetheless, to the extent plaintiffs intended to bring a claim of false advertising under a provision of the Lanham Act that they have not cited, such a claim would be subject to dismissal. Okay, maybe that's where we found the issue. If this somehow was a typo or something, that maybe Randy put in a typo, maybe it was A1, A1B or something. I don't know. But the judge is saying that the citation used does not match the claim. that would be a problem. So we'll have to look it up and see what happened there. A plaintiff must establish that 1, the advertisements of the opposing party were false or misleading. The advertisements deceived or had the capacity to deceive consumers. And 3, the deception had a material effect on purchasing decisions.
He didn't seem to have
4,
a problem though about citations. Like I said with Bruce. Remember when Bruce said, "Oh,
he really didn't have any problem with Bruce's citations that were all wrong.
yeah," he was just like, "Oh, I'm just going to ignore all that." Period.
Yeah,
It's
what the hell, man? Why
it
didn't
is.
he care about that?
Yeah, I'm not saying that if it's wrong, it's wrong. I'm just saying that maybe if you care, you care.
Mm-hmm. Mm-hmm. Craig Bucalo, thanks for the huge hondo. Yeah, I need a button for that. I need a button. Let's see, which button should I use? We'll use this one. Nice. Thank you for the hondo. It's a hondo and you know it. Not a troll, but I'm sending some breadstick money. Yes. Thank you. I appreciate that. I could use it. I have like MRI bills and it's ridiculous.
Well, what these people, you notice one of the things that they are trying desperately right now to do is they're trying to drive people off of covering this. They have tried so many different ways of doing that. They've tried it. They tried it with threats.
The very bitter end, and whether win or lose, we're going to tell you what happened. Read the documents and just discuss it, especially because they don't want us to.
Yep. Well, again, they really want somebody to stop paying attention because, like I said, there's 100,000 plus reasons that certain people want you to stop paying attention.
Mm-hmm.
Big time. And that, I think that thing right there, instead of spending, again, they would have been better off having Hales consuming quite a few resources in Fed 2 instead of having some of those resources to perhaps pursue other interesting items, like, I don't know, finding getting law enforcement involved.
Yep. All right. Here, plaintiffs have not plausibly alleged that defendant Lee used false and misleading advertisements that deceived or had the capacity to deceive. Unlike advertisements, the statements allegedly made by defendant Lee on YouTube or other social media outlets do not propose a commercial transaction. Stating case law, rejecting a claim that blog posts that were critical of the plaintiff's medical practice constituted false advertising in violation of the Lanham Act. And another case law stating that for Lanham Act false advertising claim, an advertisement must be commercial speech, and commercial speech is speech which does no more than propose a commercial transaction. Instead, what defendant Lee is alleged to have done would be better described as communicating information, expressing opinion, and reciting grievances regarding plaintiffs. And more case law that quotes, the mere fact that the parties may compete in the marketplace of ideas is not sufficient to invoke the Lanham Act. Affirming dismissal of Lanham Act false advertising claim that was based on the defendant's allegedly false and disparaging comments regarding podiatrists and the quality of care they provide. The fact that defendant Lee may have solicited donations or offered premium subscriptions on her YouTube page does not give rise to a cause of action for false advertising under the Lanham Act. See more case law rejecting the argument that the placement of articles next to revenue-generating advertising and the ability of a reader to pay for a website subscription would be sufficient for articles to be deemed commercial advertising for the Lanham Act purposes. Accordingly, count 3 of the second amended complaint should be dismissed. And we have another footnote. Any doubt about whether plaintiff has stated a plausible claim under the Lanham Act can be resolved by considering the purposes of the Lanham Act. The act was designed to make actionable the deceptive and misleading use of marks in interstate commerce. 2, to protect registered marks used in such commerce from interference by state or territorial legislation. 3, to protect persons engaged in such commerce from unfair competition. 4, to prevent fraud and deception in such commerce by the use of reproductions, copies, counterfeits, or colorable imitations of registered marks. And 5, to provide rights and remedies stipulated by treaties and conventions respecting trademarks, trade names, and unfair competition entered into between the United States and foreign nations. Describing the purposes of the Lanham Act. The allegations against defendant Lee in this case in no way seek to vindicate the listed purposes of the Lanham Act. 3. Tortious interference. In count 4, plaintiffs allege defendant Lee tortiously interfered with business relationships. Under Florida law, the elements of tortious interference with a business relationship are 1. The existence of a business relationship that affords the plaintiff existing or prospective legal rights. 2. The defendant's knowledge of the business relationship. 3. The defendant's intentional and unjustified interference with the relationship. And 4. Damage to the plaintiff. Here, the second amended complaint alleges that plaintiffs had a business relation with YouTube and Whatnot, as well as other companies and unspecified customers. There is no cause of action for tortious interference with a business relationship to the community at large. Additionally, a tortious interference claim requires the plaintiff to show a business relationship with identifiable customers. I don't know how you do that on YouTube. Am I supposed to say my customer is I Have My Favorites and Rozilla's Realm? Like, do I have to list my customers by their names, my viewers by their handles? This is the thing I don't understand. Why can't you call them customers without, why do you have to identify them by name? Is it because maybe these laws were written for corporations and customers are like other business and customers are other businesses that would have a name, like let's say a paper company loses its business relationship with their paper supplier under their GE or whatever. And so then they can go, well, we lost this contract with our customers GE because of whatever. But I mean, how do small businesses use this then? How is a small business going to name all its customers? I don't understand. How does Walmart name its customers? So I guess you can't use I guess it doesn't apply. I guess he's saying it doesn't apply to people who can't name their customers one by one.
So that becomes a problem then.
It does become a problem, I think.
Well, especially for digital, again,
the digital world. Yeah.
Well, I mean, we sell a different type of service, so it's strange. I mean, you're going to end up with a lot of, I get defamation claims, but beyond that,
Look, Hurricane sent me $10 to say this. Why does he have to show proof? That's not what I said. I said, why does he have to name every customer? But also, thanks for the $10, dummy.
Hey, they're going to give you $10. That's awesome.
If you're going to give me $10, I'll read that all day long. This is insufficient. Okay, so plaintiff's second amended complaint does not identify any customers. It simply generically refers to customers. That is insufficient. So are you supposed to say Mary Jane from Ohio and Susie Q from Tennessee? I mean, it's crazy to me. That is insufficient to state a claim. The same is true with regard to the plaintiff's allegations involving their business relationships with other unidentified companies. I can see that. I can see that you would have to name the companies. I get that. Dismissing tortious interference claim because allegation that the defendant interfered with sales to various customers was too vague and abstract to satisfy the first element of a tortious interference claim. More case law. When pleading the existence of a business relationship, plaintiffs must specifically identify in their complaint the customers or clients that are the subject of a defendant's alleged interference. But when you have 750,000 of them, is he supposed to just list all 750,000 handles? This doesn't make sense. I'm going to have someone explain this to me. Yeah. As for the allegations regarding YouTube and Whatnot, plaintiffs have alleged existing and specific business relationships. So the first element of a tortious interference has been plausibly alleged. The court will assume that the plaintiff's general statement about defendant Lee's knowledge of those business relationships is sufficient to satisfy the second element. See this case law, finding that the defendant's knowledge of business relationship need not be pleaded with specificity. That leads to the third element, which is where plaintiffs have a problem because they have not plausibly alleged that defendant Lee intentionally and unjustifiably interfered with plaintiff's business relationships with YouTube and or Whatnot. Although there are allegations that defendant Lee posted content about plaintiffs on her own YouTube channel, plaintiffs have not plausibly alleged that defendant Lee contacted YouTube or whatnot representatives or otherwise did anything to interfere with the business relationship that plaintiffs had with YouTube and whatnot. Have not plausibly alleged that she contacted YouTube or whatnot. Didn't she say she did?
Did they put that? I don't remember. I'd have to.
I don't
look
know if
back
we'd have to look back at the complaint. But I do understand that if they didn't put it in the complaint that this was done, this was that she did these things, and here's how and when. But I'm sure they also were counting on finding some of these things in discovery, right? Because I don't think what they have are statements from her saying that she interfered.
They actually do with Olite, though. They absolutely.
Yeah, we do have the thing. Yes, for sure.
And there are, I believe there are statements with her talking about contacting platforms and more. So, you know, and I mean, Olite would be the.
She also said she contacted his school where he was, he teaches auctioneering school.
Right. But that happened after the fact, did it not?
I don't know.
I believe that happened after, again, somebody that's more on the timeline than I am right this second could really definitively state this. But I keep thinking that happened after the Fed 2 filing.
Okay, plaintiffs blah, blah, blah. Affirming dismissal where there was no allegation that the defendant conveyed the information in question to the entity with which the plaintiff had a business relationship. Nor is there any allegation that because of defendant Lee's conduct, YouTube or whatnot terminated or otherwise altered their business relationship with the plaintiffs. I know that whatnot did alter their position. They altered their business relationship somehow. I don't know if Jeremy's talked about it or discussed it in detail. But there was all kinds of drama about whatnot after Bruce did what he did. I don't know if Lisa was involved in that or not. Thus, plaintiffs have failed to plausibly allege. You going to bed?
Yeah.
All right, give me a kiss. Love you. Love you too. That was a very wet, just brushed teeth kiss. Yuck. Yuck. Wipe your mouth off next time. Dang. I just got a mouthful of water. Thank you.
At least they're clean, right?
That's true. At least he did just brush his teeth. Thus, plaintiffs have failed to plausibly allege the third element of a tortious interference with business relationships claim. Plaintiffs have also failed to plausibly allege the last element, damages. Damages are an essential element of a tortious interference claim. Thus, dismissal is warranted if a plaintiff fails to plausibly allege damages suffered as a result of the breach of the business relationship. This means that the plaintiff must connect the loss of a business relationship to the alleged tortious conduct of the defendant. Here, plaintiffs seek $1.8 million in damages for defendant Lee's tortious interference, but the allegations in the second amended complaint fail to plausibly connect defendant Lee's supposed tortious interference to the breach or loss of any business relationship with YouTube or whatnot. Nor does the second amended complaint allege the value of any such business relationship that was lost or breached as a result of defendant Lee's conduct. Thus, plaintiffs have failed to plausibly allege the fourth element of a tortious interference claim. Because plaintiffs have failed to plausibly allege several elements of a tortious interference with business relationship claim, count 4 should be dismissed. And then the civil conspiracy gets dismissed because the underlying claims fail. That's all this says.
Yeah.
So not even going to do he's not going to look at the conspiracy claims. He's just saying what happened with the other, because the other claims fail, so does this one.
That would make sense, actually. You know, if the other claims did not exist, then that cannot exist.
And it says here, and because the underlying claims fail, the civil conspiracy claim necessarily fails. So he's not going to do an analysis of the actual claim for conspiracy. He's just saying the other ones fail, so that one does too. Accordingly, the civil conspiracy claim against defendant Lee in count 6 should be dismissed. And then we have a footnote that says, even if the second amended complaint had stated a plausible underlying claim, the civil conspiracy claim would still be subject to dismissal for failure to state a claim. A civil conspiracy claim must contain clear, positive, and specific allegations. General allegations of conspiracy are not sufficient. I don't know how much more clear it can get to say, we have an email from these people saying we're building an anti-Hales media ecosystem because we want to destroy Jeremy Hales's YouTube empire. I don't know how much clearer it gets than that.
Well,
or conspiracy. I don't.
Well, with conspiracy doesn't have to just be proven that way, though. It can be implied conspiracy. You know, there's it doesn't even have to be that clear. If you look up conspiracy, rules,
it's whatever. It is insufficient for a complaint to vaguely tie events together by alleging in conclusory fashion that the circumstances unfolded pursuant to an agreement between the defendants. Plaintiff may not broadly allege that all defendants conspired together without specific statements of fact which support the claim. What about the email? We're building the anti-Hales media ecosystem to destroy his YouTube empire.
Well, the thing, okay, with that, like what I mean too, with implied conspiracy, you don't have to have it written down or even explicitly stated. For a jury, they can step up and they can infer it based on behavior. So for them to have it written down, that's just this next level.
If you cannot say that a written plan to take down a man's business is not enough for conspiracy, nothing is. Like, nothing is. If that's not enough, nothing is. It's just ridiculous. I don't understand it at all.
Again, but I'm going to say it. Big Mignogna, his claim was tortious interference. These people, they didn't just allege these horrible things, but they contacted every place of business that was going to host him. He had proof that they had done this. He had proof that they had called. They even threatened sponsorship withdrawal and everything else. And it wasn't enough. So these, it's like the courts, you're told that if somebody damages you, you can get justice, but getting justice is not an easy road. Like I said, the stuff, it's fascinating though, because of Hale's lawsuits, like the wins that you have. The funniest thing about this is the wins you have were reactions, because, Lynette and her counsel were like, we're going to get you, thumbnail lawsuit, trespass 5. And they, their reactions to what he did, they caused them loss. So again, Fed won, and especially with Fed too, that really pushed them over the edge. Their reactions have been just damning and devastating for themselves.
So it says here, instead of clear, positive, and specific allegations, the second amended complaint contains conclusory allegations of an agreement without any factual basis to make the allegations plausible. The second amended complaint alleges a sprawling conspiracy involving people from across the United States, all of whom share one thing in common. They have said negative things about Plaintiff Hales on social media, but there are insufficient facts alleged to plausibly show an agreement between all the members of the supposed conspiracy to engage in an unlawful act or a lawful act by unlawful means. Thus, dismissal is warranted. A complaint may justifiably be, well, we don't know what would have been found in discovery also. I think the email or the Facebook message from Bruce saying we're doing this and we're going to take down his YouTube empire is certainly enough to get past that hurdle.
Two of them. Yeah. We're building an anti-what the hell's media ecosystem.
Not to mention he contacted YouTubers specifically with the goal to recruit them into the anti-what the hell's media ecosystem to continue that conspiracy to take down Jeremy Hales. And we have those.
Yeah. But again, it's what is it stated the way that,
is it stated the way that they want it in their magic words? It has to be it's a formula, like an algebraic formula. If you don't have it,
beyond that, I think it's more than that though. I think with him, like, again, I really do wonder if this case would ever have been allowed to win with Bolitho.
No, I don't think so either. We're getting to that. That part is coming. Amended complaint alleges defendant Matskin tortiously interfered with plaintiff's business relationship and also participated in conspiracy count. The law regarding what is necessary to state a claim for tortious interference is set above and will not be repeated here. The second amended complaint alleges that Matskin tortiously interfered with plaintiff's contracts and advantageous business relationships with its customers or other companies, including but without limitation, Whatnot, and YouTube. Defendant Matskin argues the plaintiff's allegations are insufficient to state a plausible tortious interference claim. The court agrees with Matskin. First, as explained above with regard to defendant Lee, a tortious interference claim requires the plaintiff to show a business relationship with identifiable customers. Here, plaintiff's second amended complaint does not identify any customers again. It simply generically refers to customers. That is insufficient to state a claim. The same is true with regard to the plaintiff's allegations involving its business relationships with other unidentified companies. Okay, we already read a lot of this. It's all the same as what was in Lisa Lee's. Thus, they failed to allege defendant Matskin tortiously interfered. Regarding the allegations involving Whatnot and YouTube, plaintiff has alleged existing and specific business relationships. So the first element of a tortious interference has been plausibly alleged, and plaintiffs have plausibly alleged that Matskin had knowledge of those relationships. That leads to the third element, which is again where plaintiffs have a problem, because the second amendment complaint fails to plausibly allege that defendant Matskin intentionally and unjustifiably interfered with plaintiff's business relationships with YouTube and Whatnot. Although there are allegations that defendant Matskin posted content about, no, the allegations are that he contacted them, not posted content about him, that he contacted Whatnot, that he contacted YouTube, and we have copies of that stuff. Plaintiffs have not plausibly alleged that defendant Matskin contacted YouTube representatives or otherwise did anything to interfere with the business relationship. This is bullshit. Because he did. As for Whatnot, plaintiffs have alleged that defendant Matskin had contact with Whatnot representative during an email exchange regarding discovery in one of the other cases plaintiff Hales has filed. But plaintiffs have failed to plausibly allege that this contact with a Whatnot representative actually interfered with plaintiff's business relationship. More specifically, there are no allegations that Whatnot terminated its contract with plaintiffs, denied plaintiffs access to the Whatnot platform, or otherwise altered plaintiff's business relationship. I do believe it was, though. At least for a time. He may have gotten it back, but it was. Now, is that a mistake, a problem that it wasn't written out like that in the complaint? That is what the judge appears to be saying.
That's one of the things that's interesting about curing deficiencies in this. If there are deficiencies in here, you're not allowed to cure those deficiencies and add them. Okay, well, if you want proof, then allow us to add proof, you know? Mm-hmm. That would be something, again, I would think that would be something that you would
but he doesn't even want to give them that opportunity. He wants to dismiss with prejudice.
Yeah. That's why, arguing wise, again, when they put in their argument about this, then that would be something, and it will be in there, of course, but I think that's something to really hammer is the fact that, yes, we have proof, 100% that we can show. So, if we need to, we should be allowed to, again, cure these deficiencies and bring that forward.
Mods, you have the right to time out people who are attacking others in the chat. If the trolls are getting out of hand and attacking people in the chat, then time them out. And trolls, just troll me, okay? Don't troll the chat. I don't know what you're doing because that'll get you booted. So don't troll the chat. You can troll me. Troll Tug. We don't care. But please leave the ladies in the chat alone, especially the grandmothers, please, who aren't feeling well. Please don't do that.
Teach Megan a lesson. Send her another $10 super chat.
Send me another $10 and teach troll her. Me.
What a monster. Show her. Put her in her place. That's what I do. When Megan gets out of hand, I throw $10 bills at her.
Throw $10 bills at me. Yep. That's
Damn
how
you, Megan, get your hole.
My money. Oh my God. No, he did not read anything, William. William sent 10, says, this is the third time it is clear that Bolitho did not fully read motions by saying Randy never claimed BBB contacted YouTube or whatnot. Did he not read the attached emails? No, he didn't. Because all of this has been given as exhibits in one way or another.
That's the way you highlight it. You're like, hey, right here. That's my,
Yeah, it's ridiculous. This third part here is all about how they're saying plaintiffs did not connect monetary damages to the actions. Same as in Lisa's. I'm not going to read through the whole thing. It's exactly the same as what it says in Lisa's. Civil conspiracy, that's dismissed because the underlying claims, for the same reason, are dismissed. Defendant Cook's motion to dismiss. Count 9, plaintiff's claim. Ooh, we're on page 31. We're doing good. Plaintiff's claim defendant Cook is liable for civil conspiracy.
That's the only thing I'll miss is John Cook filings, because those are really funny.
Those are always funny. Defendant Cook has moved to dismiss for failure to state a claim. The civil conspiracy claim against Cook fails for the same reasons discussed above. Accordingly, count 9 should be dismissed. Defendant Hughes, and that's going down as well. This is all says the same thing. These paragraphs are all the same, that they're dismissed for the same reason. Defendant Helms' motion to dismiss. Now, his is different because he filed an anti-SLAPP defense.
Yep, which will, if dismissed, will entitle him to quote-unquote reasonable attorney fees.
Yeah, it will. He will be allowed to get fees for what was spent in filing his motions.
Mm-hmm.
Defendant Helm has moved to dismiss for a failure to state a claim. The civil conspiracy claim against defendant Helm fails for the same reasons discussed above regarding plaintiff's civil conspiracy claim against defendant Lee. Aside from seeking dismissal, defendant Helm seeks to recover his attorney's fees under Florida's anti-SLAPP statute. There is a question, though, as to whether the anti-SLAPP would actually work in federal court, by the way. So that's not a for sure thing. We do not know yet if Florida's anti-SLAPP statute applies to the federal case. So that's something that needs to be looked at probably. Florida's anti-SLAPP statute prohibits a person from filing a cause of action against another person or entity without merit, and primarily because such person or entity has exercised the constitutional right of free speech in connection with a public issue. It further provides that a court shall award the prevailing party reasonable attorney's fees and costs incurred in connection with a claim that an action was filed in violation of this section. According to defendant Helm, the anti-SLAPP statute entitles him to reasonable attorney's fees because plaintiff's allegations are without merit, and this lawsuit was commenced because defendant Helm exercised his right to free speech by appearing on YouTube broadcast to discuss plaintiff Hales and other lawsuits plaintiff Hales had filed. In response to defendant Helm's motion to dismiss, plaintiffs have argued that their claim against Helm has merit and that defendant Helm's speech was commercial speech that is not covered by the anti-SLAPP statute. Defendant Helm has met the anti-SLAPP statute's first requirement because, as explained above, plaintiff's claim against him lacks merit. Well, no, you didn't explain how it lacks merit, though. What do you mean, as explained above, it lacks merit? Where was the judge's explanation of how that was the case in the law? Did you see it? Because I didn't.
Wait, is it a claim of tortious interference that he's talking about, or a Lanham Act claim?
I don't know. Maybe he's saying the first claim against him lacks, but I don't know. But he didn't give us
again, Hale, Stupid Dave.
Yeah, I didn't think any of them would survive this.
Yeah, Ray potentially. I mean, there was the stuff he said after it was filed, but that stuff wasn't included in the filing. So unless that was amended, potentially he would have been a problem. I think you had a few, like a handful of strong contenders, and then you had other people that were weaker contenders. They're harder to loop in,
The anti-SLAPP statute defines free speech in connection with public issues as any written or oral statement that is protected under applicable law and is made before a governmental entity in connection with an issue under consideration or review, or is made in or in connection with a play, movie, television program, radio broadcast, audiovisual work, book, magazine, article, musical work, news report, or other similar work. Free speech made in connection with public issues in pertinent part merely requires a showing that the public speech is contained in or was made in connection with one of the listed media formats or other similar modes for widely disseminating protected First Amendment speech. Here, the allegations in the second amended complaint involve oral and written statements made by defendant Helm that were protected under applicable law. The oral statements were made as part of defendant Helm's operation of a YouTube channel called Making Law Simple, and the written statements were made in connection with a YouTube broadcast that was being conducted by defendant Lee on her YouTube channel. These YouTube broadcasts are audiovisual works or similar works, and in the current world, YouTube is undoubtedly an other similar model for widely disseminating protected First Amendment speech. Well, maybe you should tell that to the court, the federal judge that went after Andy Senior and made him turn over his sources.
Right. That was insane.
You know, this court clearly doesn't agree with the other court in Florida that said, no, YouTube doesn't count.
That's the problem with courts. You know, we can have all the law you want, but you have these little dictators in their own little private fiefdoms that decide
right?
how it applies and who it applies to.
Yeah. Interesting, because that was a federal court in Florida, too.
Yep.
Thus, the requirements of Florida's anti-SLAPP statute have been met. In an attempt to avoid this conclusion, plaintiffs argue in cursory fashion that the anti-SLAPP law does not apply because the lawsuit was aimed at defendant Helm's unlawful conduct, which includes but is not limited to actionable commercial speech. Plaintiffs' argument that the allegations against Helm are based on conduct and not speech is incorrect. The gravamen of plaintiffs' allegations against defendant Helm are things he said and wrote, in other words, his speech. And that's, well,
Wait, so does that mean I can say or write anything I want?
I guess you could say or write anything you want.
You know, like I said, these lessons though, these go two ways. So everything these weirdos have said that they're going to sue over, just remember it goes both ways.
Yeah, but also I believe that the complaint was alleging that Helm did things, not just said things, but did things behind the scenes that led to a lot of the conspiracy stuff. That was the allegation, that it wasn't just the things he said, but it was things that they alleged he did, including one of them. I don't know if it made it into the complaint, but apparently he went to Ohio and took pictures of himself in front of Jeremy's property, like stalking his house and stuff, which is weird. I mean, I got to admit, that's weird. I don't know why.
Did he really? Again, though, you know, unfortunately with cases, that stuff, I mean, like I said, these are two-way streets. So if people think that's okay, all right, well, they live places too.
Yeah.
That's
apparently it's okay to go to somebody's house and take pictures of yourself in front of it and be weird and creepy and tell people you're, you know, going to Jeremy Hales' house and stuff. So I don't know. Don't complain. Don't complain, Ray, when people show up and take pictures of your yard or whatever.
Actually, whatever. All the stuff he's been complaining about, it's okay. As long as people don't go on your property, apparently it's all good.
Mm-hmm.
You know, so if I want to go pose with somebody's mailbox or, you know, also the other thing, they keep talking about family and everything else too. Okay, well, I guess that's two-way street. You know, the lesson here, again, is everything... everything that they do also can apply to them. And if there is no legal recompense for it, then, well, you got some real serious problems, you know.
Mm-hmm. The core notion of commercial speech is speech which does no more than propose a commercial transaction. See case law. Our commercial speech doctrine rests heavily on common sense distinction between speech proposing a commercial transaction and other varieties of speech. And we have a footnote. Even if it was commercial speech, that would not mean it was unprotected speech. See this case law, recognizing that commercial speech is accorded a measure of First Amendment protection, but that protection is more limited than the protection afforded to non-commercial speech.
Wasn't one of the comments about the signs? Wasn't that part of the thing too, about the signs that were posted?
Yeah, I think so. Where he said he saw Jeremy Hales plant the signs or whatever. Mm-hmm. Here's defendant Helm's speech. Here, defendant Helm's speech did not propose a commercial transaction. Rather, defendant Helm's speech consisted of commentary and criticism regarding plaintiff Hales. As such, it was a written or oral statement that is protected under applicable law and within the definition of free speech in connection with a public issue for purposes of Florida's anti-SLAPP statute. Because plaintiff's claim against defendant Helm is without merit and was filed primarily because he exercised the constitutional right of free speech in connection with a public issue, plaintiffs should be required to reimburse defendant Helm for his reasonable attorney's fees and costs in defending against this lawsuit under the anti-SLAPP statute. Then Teschendorf's is dropped for the same reasons as all the others. About now they're going to go into the jurisdictional stuff about serving him, I think. Mm-hmm. But all it says is that, yes, he is under our jurisdiction. All of this to say it is the jurisdiction is correct. So they found that Dave claiming that there's no jurisdiction, the court said, yeah, there is. Okay, so I don't need to read all of this to tell you that the court finds that plaintiffs have satisfied the Calder effects test. Plaintiffs have alleged that defendant Teschendorf's conduct was intentional, and they have alleged that defendant Teschendorf's conduct was aimed at Florida. His YouTube channel was accessible in Florida. He allegedly used his YouTube channel to make comments about plaintiff Hales' actions in another Florida lawsuit and plaintiff Hales' conduct in an ongoing saga involving a neighboring property owner in Florida. Under the circumstances at issue, defendant Teschendorf should have anticipated that any harm caused to plaintiffs would be suffered in Florida. Accordingly, defendant Teschendorf had sufficient minimum contacts with the forum state to satisfy due process. And so they find that, yes, they have personal jurisdiction over Teschendorf. And it says the court finds that exercising personal jurisdiction over defendant Teschendorf would comport with fair play and substantial justice, but would put your back at serious risk of injury.
I just like all the stuff Dave whines about and stuff, though, like addresses and all of that stuff. Apparently, it's all good to go. It's all gravy. Everything is.
My joke went right over your head. Right.
No, I didn't hear it.
I said exercising personal jurisdiction over defendant Teschendorf would comport with fair play, but it could injure your back substantially.
Oh, yeah. Exercise. That word doesn't seem right anyway with him. It's hard for me to imagine exercise.
So the failure to state a claim, they're saying yes, that should be dismissed because of that. And the conclusion, we did it, Doug. We made it to the end.
Oh my God, how did that happen?
It says defendant Teschendorf also seeks reasonable attorney's fees under Florida's anti-SLAPP statute. But defendant Teschendorf is not entitled to such fees because he is proceeding pro se. He has no attorney.
Exactly. There you go. With all these people, so they thought they would get money off Hales because he filed something. Here's your dun dun dun. Yes, you don't get shit.
You don't get shit because you didn't hire a lawyer.
Yeah, so they should have all hired lawyers. We told them to hire lawyers.
We did tell them that.
We did, but or then they didn't. So they don't get to parade around any money. Poor kids.
Now, here's the conclusion. For the reasons above, it is respectfully recommended that defendant Helms' motion to dismiss be granted and the claims against defendant Helm dismissed with prejudice for failure to state a claim. Wait. Is this just saying that the claims against Helm are should be dismissed with prejudice? Just against Helm? Hold on.
They have others.
Here's a footnote. Yeah. There is no basis for providing plaintiffs with another opportunity to amend. Plaintiffs were previously given an opportunity to amend after defendant Helm filed a motion for more definite statement. Plaintiffs are represented by counsel, and the 11th Circuit has never required district courts to grant counseled plaintiffs more than one opportunity to amend a deficient complaint. Case law says it's unnecessary to allow plaintiffs who are represented by counsel the opportunity to file further amended complaint. Here, plaintiffs have already been given an opportunity to correct their pleadings.
So if I were pro se, then they would give
me. And you could amend it however many times you wanted. Yeah.
Good God, that's stupid.
Yeah, it is. But also, wait a minute. It says here plaintiffs have already been given an opportunity to correct their pleadings only in regards to Helm. Helm was the only one that asked for an amendment. So it wasn't like Randy was told, oh, here's some other problems with your complaint that you have a chance to amend. This is the first time that the judge has commented on this stuff.
I wonder if that matters within that, you know, because you were asking about the others with prejudice. He notes the others, but there's no footnote noting the others.
There's no footnote noting the others. So yeah, is he only recommending dismiss with prejudice against Helm?
I think I'm going to have to call it a day. I think I've hit my wall,
Okay.
you know, so.
All right. Well,
I hate
you go.
to just bounce off
It's
it
all
here.
right,
but,
because we're almost finished here. So
all right. Well, I'm just going to have to call it. All right. I'll catch you all tomorrow. See ya.
Feel better. Moreover, plaintiffs have not moved for leave to amend in the manner required by Rule 15A2. Instead, plaintiffs have simply stated in their opposition responses that if the motions to dismiss are granted, the court should afford plaintiffs an opportunity to amend to address any perceived defect. That is insufficient. See this case, affirming dismissal with prejudice where the plaintiff had previously amended and opining that the plaintiff's statement at the end of the response to motion to dismiss was insufficient to formally seek leave to amend under Rule 15A2. Dismissing with prejudice and stating that rather than requesting leave to amend his complaint a second time, before the court ruled on this motion to dismiss, plaintiff sat idly by as he awaited the district court's determination of defendant's second motion to dismiss. Dismissing without leave to amend and explaining that the plaintiff failed to properly seek leave to amend because instead of filing a motion, plaintiff merely mentioned in his response to defendant's motion to dismiss that if he has failed to state a claim, then he should be given leave to amend. Defendant Hughes's motion should be granted and the claims against Hughes dismissed with prejudice for failure to state a claim. So yeah, they're all with prejudice. He wants them all dismissed with prejudice, including against Matskin, Cook, Lee, Bonebreak, Kesey, Teschendorf. This matter be recommitted to the undersigned for further proceeding involved defendants Preston and Luthman. And there's a footnote, number 14. As stated previously, this case is stayed as to defendant Preston because of her pending bankruptcy. With regard to defendant Luthman, the issues raised recently became ripe and remain under consideration by the undersigned. This matter being recommended, as well as the determination of the reasonable attorney's fees due to defendant Helm under Florida's anti-SLAPP statute. Okay, we did it. We got through it. Obviously, there's going to be a lot of questions. I can't answer a ton of them because I don't know. I don't know the answers to them. But we did tell you that this was going to be a tough road. Tortious interference always is. Conspiracy always is very difficult also. And I have always felt stronger about Fed 1 than Fed 2. And I would like to see Jeremy crush them in Fed 1. And I think it's possible. I don't know. I do know that Randy will, of course, object to I'm sure he will object to the finding. And it has to still go in front of the district judge. And the district judge could do a couple of things. He could affirm everything Bolitho has said and sign it and it'll be done. He could agree with Randy on some things and disagree with him on others. And so he could keep some of the claims and dismiss others. He could agree with Randy totally. We'll just have to wait and see what happens, and that's the way that the courts turn, guys. You never know what's going to happen. All right, I'm going to get to super chats and super tips right now. Actually, I forgot to open super tips. I got to do that. Let's get over there. I've got a fun outro for you guys tonight too. I got a new one for you. That I worked on. Max Lab, thanks for the $1. I appreciate you, sir. Tracy Wilden gifted 5 Megan Fox memberships. Welcome to the Fox Den, all 5 of you. It's weird here, but you will get used to it. Fallen Hero 4567 gifted another Megan Fox membership. Welcome to the Fox Den. Thanks for being here. Badger John, thanks for the 5. Do you think that Jeremy should get a new lawyer, one that specializes in the internet stuff? No, not particularly. I mean, look, you can only, all lawyers lose motions sometimes. All lawyers you're going to lose once or twice, or many times. That doesn't mean that he's not doing a good job. It doesn't mean, it just means that it's a difficult case. And it was always going to be a difficult case against 10 different defendants who act the way these people act and who do the types of underhanded things that they do and that they've done. It was always going to be an uphill slog. The poisoning of the well happened with Bolitho. And there was I guess, I don't know if I missed it. Because, I was looking for that one thing. So it was under the Matskin stuff. Hold on, let me go back. Because there was something in here under the Matskin thing that I may have missed. Hold on. It was before Hughes. Oh, yeah, here. Where the judge made a comment about how he told plaintiff's counsel not to file this. I can't remember where I read it, though. It was in the Matskin thing where he referenced telling plaintiff's counsel that he shouldn't be filing against Matskin, which made me think, and I don't know where it went. I haven't found it. I don't know where it is. I'm looking, but I'm not seeing it. But he referenced that somewhere. I don't know why I missed it. And it made me think back to the transcript of the Pensacola meeting that they had, where the judge told Randy that he didn't think he should file against Matskin. Because do you want to be the kind of lawyer who files against other lawyers? He said something like that. I think that right there was the moment he decided if that case landed in front of him, it was going nowhere. I think he's been biased against this case since that day, and I don't know why. No, I don't think he needs a new lawyer. So I think he needs a new judge in this case. I think that the judge has been real bad in a lot of ways. Frankie, thanks for the 5. I don't understand why Bolitho brought up Jeremy Hales' case against the state prosecutor. I do, because he does not like Jeremy Hales or his lawyer for whatever reason. And he hates this case and he wants to make it disappear. And I don't think that the system really likes it when you file cases against their own. And a prosecutor is one of their own. Blake Rich, member for 4 months. Thanks for being here. Rogue Mama, thanks for the 2. Is Spawn in the black chair? The black chair. No, she's not in a chair. She's in her bed. But it would be funny if she was in the black chair. I've got a. Here we go.
I've done nothing except get pregnant by the fucking Bachelor.
I couldn't get through a show without doing that. I had to play that. Rogue Pirate, thanks for the 2. Megan, stop raising Tug's blood pressure. He's not that slow. Dinah's mom, thanks for the 5. We need to put you in hangry in bubble wrap. Glad she's healing. Yeah, me too. And Sherry Worthen, thanks for the 2. Saying so, not injure yourself anymore. Yeah, I know. We need to stop injuring ourselves. Cajun Bayou Queen, CBQ removed the curse from the Fox family. If it don't work, sorry, you're doomed. This Hurricane Von Hurricane, thanks to the 2. I got here in time for all the cope. Oh, yes, we're just coping very hard. This is, I don't really know what you mean by that. I think we're having a good time. Hurricane Von Hurricane again, thanks for the 5, trolls. You're so worried about bias. Maybe the case just sucks. Be objective. Yeah, I mean, it's possible that, and like I said, I cannot comment on the Lanham Act and the FDUPTA claims because I don't know either one of those laws very well at all. So we're just kind of learning as we go here about those. And I'm interested to see what Randy's argument will be in response to what the judge said. And it's absolutely possible that, yes, maybe this case is not great. I don't think we ever argued that this case was the best case we've ever seen. I believe we have told you from the beginning, Tug and I both said, we believe that this case is going to be very hard to win. Tortious interference claims are hard to win. All the tortious interference cases we've ever seen have been very difficult to win, and the people who brought them did not win. So, yeah, I mean, I think we are being as objective as we can be. We definitely, though, do see that these people have harmed Jeremy Hales. Whether or not he can get justice for it is the question. Is there a way to hold people who harm you professionally accountable? It doesn't seem so far. Seems like you can just go out there and harm anybody's business and you can't be held accountable for it. I think that's the real problem. Jack Miles, thanks for the 2, Bolitho Fed version of Judge Grudge. You know, as bad as Bolitho is, I don't think he's as bad as Judge Grudge. At least he's not as overt. We'll put it that way. Deftones Andy, thanks for the 2. LOL. And William Allen, thanks for the 5. Bolitho bought into the poor, indigent, elderly mother and clearly did not like Jeremy Hale suing her. His bias around this has been clear from the beginning. It's true that he did make statements about that sort of thing, including trying to raise money for her to have a lawyer, and that I've never seen before. Using bench funds to entice attorneys to come and represent her was insane. Not sanctioning her attorney who refused his orders and wouldn't show up was outrageous to me. He did a lot of things that were really bad. Hurricane Von Hurricane, thanks to the 2, but you could try to be more creative next time, okay? I'm not going to read that again. Paul Harding, thanks to the 5. Free press and public criticism are essential safeguards against tyranny. Hamilton, especially with public officials. That's right. That's why I'm going to say whatever I want to say about whatever judges or elected officials are acting badly, and Bolitho is one of them. Amber Lynn, thanks for the 2. Hurry, start blaming. You both sound dumb. Well, thanks for your opinion and your money. I'll take it all day long. Deftones Andy, thanks for the 5. LMFAO, Germ is choking on this lawsuit. Clean it up. Oh, wait, you can't. Well, we're just reading the lawsuit here, okay? We're reading the orders. That's what we're doing. We're bringing the information to the audience. You can laugh all you want about it, but in the end, I don't think that it's going to be Jeremy who's the one with all the losses. He's already racking up a lot of wins in his other suits, plus the bankruptcy court. So we'll just have to wait and see how it goes. Fallen Hero, thanks for the 5. For the medical bills, I appreciate that. Auntie Annie, thanks for the 10. Late fee. Felisa will be receiving a financial colonoscopy shortly and hopefully an indictment or 2. Yeah, that's the really exciting part that we haven't even really got to talk about, is that the bankruptcy attorney who's been assigned to go after the assets they had a meeting with the creditors, and the first thing they want to do is subpoena the bank records of Felisa's. So this Fed 2 being dropped is not going to help her in any way. It is not going to help her in any way. She is in serious trouble in federal bankruptcy court, and they cannot do what they've done. They can't do there what they've done in these other cases. The bankruptcy court does not play around. Liz Barnes, member for 5 months. Question, Megan, isn't that what 2L and Gator Boy are doing to me? And I'm a senior. Cyber sexual harassment. I've reported to YouTube as such. I don't know what it is that they're doing to you, Liz, but if they are doing something like that to you, then yes, you should be reporting it to YouTube, because it's not okay. Amber Lynn, thanks for the 2. Oh, but Germ said he dropped Olight. Which is it? No, Olight dropped him, and then they tried to come back later, and he said no. Habit New Angel, thanks for the 5. I keep wondering if the potted plant judge was a student of Judge Grudge. Is he the plant revenging his mentor? If he were a student, I can't imagine that he liked him very much. We have reports from Judge Grudge's students. They hated him. Sue Scat, thanks for the 5. I can understand some clarification, but seems this judge wants to try this case on paper, in my opinion. Yeah, I mean, he doesn't want it to go in front of a jury. Deftones Andy just keeps spending money to troll. Megan, you're doing an amazing cleaning job. Tug can't manage, and Ricada would never. I don't know what you mean by that. I know you're alleging that I'm sweeping up after Jeremy Hales or something. I'm just trying to read to you the order, what it says, and how I see it. Again, throughout this entire case, I have seen the way that the anti-Hales ecosystem behaves. I think it's outrageous and offensive, and I think that they have harmed Jeremy Hales. That is my opinion. Now, my opinion on the Fed 2 case itself, we're going to have to, I need more information on whether or not I agree with this entire order from the judge. I don't think I do. I think in one in particular, he got wrong was all the stuff about Bruce contacting YouTube. We absolutely know he contacted YouTube. We have the emails from YouTube saying, stop contacting our attorneys at home, you fucking weirdo. So the idea that the judge is saying that there's no evidence that Bruce ever did any of that is crazy. So I have legitimate concerns with this order and some of the stuff in it. I am not commenting, though, on the Lanham Act or the FDUPTA claims because I don't know enough about them. Maybe those claims were weak. Maybe. Linda Early, but I know for a fact that the anti-Hales media ecosystem is a thing. They made it a thing, and they wrote down specifically that they created themselves in order to destroy Jeremy Hales. And I'm not sure that that's legal. I don't think it is. Linda Early, thanks for the 20 for medical bills. I appreciate that. McDeb, thanks for the 5. Didn't Judge Bolitho insist on talking and combining these cases because Fed 2 was assigned to a different judge originally? Well, no, what happened was Fed 2 did get assigned to Hinkle. Well, Hinkle has to assign them out, right? So it got sent to Hinkle, and Hinkle said, there's another case with the same players being taken care of by Bolitho, so that's where it should go. And by the way, I believe that's what Randy told him when he said, you need to file a separate case. Randy said it's going to get consolidated anyway, and that's exactly what happened. So I don't think the judge liked that, and here we are. Mama Bear Lee, thanks for the Canadian 5. Sorry I'm late. Hope you're both well. I've been worried about you both. Sending hugs and support from your friends from Canada. Well, thanks. I appreciate that. It was just a really difficult weekend for us with the recovery from the surgery and everything. It was just a lot. Who's Your Daddy 1775, member for a month. The bottom line is that little girl is still living in squalor, and it's really sad. SF, thanks for the 5. The judge doesn't want to deal with this anymore and hasn't wanted to for a year. He has not wanted this case. Ever since that meeting in Pensacola, it went off the rails then, and he wanted to get rid of it then. SF, thanks for the 5. If you're going to troll, at least be funny. Hear, hear. Rob Pate, thanks for the 5. Do you think the magistrate wrote this without any input from the judge? The judge seems to be much more reasonable. Possible he won't accept it as written. Yeah, I do believe he wrote it without input from his district judge. That's his job, is to keep this kind of stuff off the judge's plate. I don't know what the district judge is going to do. It is possible he won't accept it as written. He's going to have to listen to Randy's arguments about why he objects to it. And the judge could do a number of different things. Like I said, he could drop some, keep others. He could do exactly as Bolitho wants and drop them all with prejudice. He could dismiss them without prejudice. He could allow Jeremy to refile another amended complaint. I don't know. It's a wait and see. Carol Welch, thanks for the 5. Megan, check your messages. Your chat's being trolled really bad. I sent them you the picture. I know. I see the chat. It's okay, Carol. We don't mind. The trolls are going to troll, you know. The best thing to do if you don't want to deal with them is hide them. You can do that. You can block them yourself on YouTube, and then you won't have to see them, or just ignore them. But you know, here we do something a little different than they do on the other channels, which is we allow people to be critical in the chat. We allow the other side to come in here and have their say. They don't do that over on the Fleas channel. The second you disagree with them, they ban you for life. And I just don't believe in that. If you want to disagree with me and have an argument, a lot of times I enjoy that. I don't mind hearing criticism from people. And I don't, as long as the trolls are not going off, like I said, troll me, don't troll my chat. You come at me and I'll answer you. But when you go after people in the chat, that's when I get annoyed. Tizzy DeBounce gifted 5 Megan Fox memberships. Welcome to the Fox Den. It's weird here, but you'll get used to it, and you won't be able to quit us after a while. David Meadows, member for 15 months. So why advise JH to do a separate case and then let it go on so long? Why recommend dismissal for everyone but Luthman and Bonebreak? It wasn't Bonebreak. It was Luthman and Preston that weren't dismissed because Luthman is the only one that has this Florida's cyber sexual harassment charge on him, and that one he has not looked at the motions relating to that yet. And Preston has to stay in because her bankruptcy case is still going on. But as to why advise Jeremy Hales to do a separate case, I have no idea. I have no idea because he clearly didn't want to hear it. Anthony the Warrior, member for 2 months. Megan, the customers got hurt when they attacked Whatnot when they tried buying products for over $100,000 and not paying. Very true. Tizzy DeBounce, one more membership. Welcome to the Fox Den. I appreciate you all. Rob Pate, thanks for the 5. Megan, stop calling him the judge. He's the magistrate. His job is recommendation only. Judge is the decision maker. Yes, that's true. It's just the terms are kind of interchangeable in your, because he is a judge. Bolitho is a judge. It's like his, he is a judge. He acts as a magistrate in this court. But I mean, he does the same thing a judge does. But you're right. You are correct. He's not the decision maker, although he has a lot of power over this case. And Craig Bucalo, again, for the 100. Thank you so much. I appreciate that. Not a troll, but I'm sending breadstick money. Madam Mimosa, thanks to the 5. Will Randy's response rebuttal go to Bolitho or Hinkle? I believe Hinkle. That don't quote me on that, but I think it'll be Hinkle. William Allen, thanks for the 10. This is the 3rd time. It's clear Bolitho did not fully read the motions by saying Randy never claimed BBB contacted YouTube or whatnot. Did he not read the attached emails? I know. It's terrible. It's horrible. It's terrible. Sherry Worthen, thanks for the 20. For Megan's massage, well towards it anyway. Well, thank you, Sherry. I appreciate that. And again, Deftones sent $5 with an illegible statement here. More than the fleas XOXO. Okay, but thanks for the 5. Appreciate it. Deftones Andy again with the 5. Tug, serious question. Did you lose a tooth when you fell on the table? No, he didn't lose any teeth. He just got a black eye. Deftones Andy, thanks for the 10. Megan, love you. Again, XOXO, don't ban me. I'm not going to ban you. No one's banning you. Deftones, thanks for the 2. Grumpy, I am serious. Pickled Tink, thanks for being a member for 16 months. Of course, Randy was told not to send any motions until the stay was over. And now Bolitho sends this. Yeah. Deftones Andy, thanks for the 2. Love you, Meg. Gotta go. All right, you take care. And Mary Maldonado, Piss Gen Xer, member for 4 months. The Fox family, a.k.a. the Gimpy family. Love you. And Tug and Megan. Well, we love you too. And James Aaron Smith, thanks for the Canadian 2. Document 163, order John Doe must give name in any new filings. Yes, I was going to go over those tonight, but I didn't have the time with a 45-page filing, which we got through. Aren't you proud of us? Abby, thanks for the 2. JH has not given any verbal evidence in court. That's right. He hasn't. And motions to dismiss are difficult because you got to get past them. And in order to get to a jury, in order to get to discovery. So, all right, let's get to the super tips because those are a lot of fun. And let's see. You've got a couple of minutes to get in your super tips if you want to. Rosalind Duke, my bestie, thanks for the $6.34. What a weird number, but I'll take it.
The dummies don't recognize that current rules of internet comms can be opted out of without reason.
This rule is as outdated as Chester's skivvies.
Oh, Mary Lincoln, gotta love her. And Sassy Mama C.
Megan, the Lanham Act is primarily about trademark protection, unfair competition, and false advertising.
The potted plant wants more proof than just links to the anti's YouTube lives.
I can't blame the man. I wouldn't want to listen to the flea bags either, but it's lazy as fuck. He need to do his damn job.
Yeah, the thing is that there is an argument. The argument is one side says you don't need to give every bit of evidence that you have in your initial complaint. That comes later. That comes during discovery and during all of the depositions, etc. And this judge is saying, no, I needed more. So we'll just have to see what happens and we're going to learn something. And that's the good part. That's the good part about this. And that's why I do what I do and why I like doing this and why I like covering cases is because just like you, I am learning these things as we go. I definitely want to continue learning about, I love the law and I like to follow how cases go. And this is one that I've never encountered one like this before. And so for sure, if nothing else, folks, we are all going to learn together as we go. All right. That's it. We got through. Oh, I didn't check Cash App and stuff. Hold on. Because those always, Roz, thanks for the warning, by the way, about the trolls sending super tips. They didn't. So if they tried, they failed. which is funny. They couldn't figure it out, Roz. Not smart enough to figure it out. So no worries on that front. All right, let me check the Cash App real quick. Hold, please. Where's my hold music? Do, 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 do. All right. We are good on Cash App. We are good there. Do we have Venmo we need to thank? Where are the transactions? No, we are good. All right, everyone. I have a brand new outro for you today. So those of you who have stuck around all this time are going to get to see my brand new Fox Den outro. Good night, everybody. Sleep tight. Time to wind down and put the bullshit on hold.
We watched them lie, we watched them cry, fake ass tears in the courtroom sky. Grifters grift, lawyers spin, but the Fox Den always clocks the sin. Bad fate takes and crocodile please. Everybody innocent, everybody please. But we saw the receipts, we rolled the tape. Now it's time to let the bullshit wait. In the Fox Den late, we vibe, we grin, laugh at frauds, let the truth sink in. Screens go dark, but we'll be back. Same wild court, same unhinged act. In the Fox Den late, we vibe, we grin, laugh at frauds, let the truth sink in. Screens go dark, but we'll be back. Same wild court, same unhinged act. Super chat's done, the gavel's down. All the clowns left the courtroom town. Sleep real tight, don't let them pretend. Good night from the Fox Den, see you again. Bad fate takes and crocodile please. Everybody innocent, everybody please. But we saw the receipts, we rolled the tape. Now it's time to let the bullshit wait. In the Fox Den late, we vibe, we grin, laugh at frauds, let the truth sink in. Screens go dark, but we'll be back. Same wild court, same unhinged act. In the Fox Den late, we vibe, we grin, laugh at frauds, let the truth sink in. Screens go dark, but we'll be back. Same wild court, same unhinged act. We vibe, we grin, laugh at frauds, let the truth sink in. Screens go dark, but we'll be back. Same wild court, same unhinged act.